Under the Michigan court rules, the case is decided. Michigan court rules, the case is decided thereunder to the extent a conflict should arise, given the waivers, the court will send to hear the matters. The court does call the case of the People versus Gary case.
Absolutely, for the people.
Versus Gary Chase.
Absolutely, for the people.
Morning, Your Honor. William Livingston on behalf of the absence of Kerry Chase. I have spoken with Mr. Chase this morning. He's running a few minutes late. He indicates he's on his way. I don't have an ETA yet, but
Okay.
if Your Honor would be willing to pass the matter, I'll wait patiently in the back.
Your Honor, I don't mind if we just go ahead without him. Unfortunately, if the court would allow it, Mr. Chase has been here every time that we've been here. The victim in this case is just too unwell to travel. So at this time, we are not able to proceed.
You have any objection to proceeding with your client in absentia?
No, Your Honor.
All right. So people being unable to proceed, are you moving to dismiss?
Yes, Your Honor.
People being unable to proceed. This case is dismissed. That is without prejudice.
Thank you, Your Honor.
Thank you. And June 23rd.
Because that's the last time. Ready on that.
If it's safe, Lee would fill it up. And it was good water. But now he's back. I'm gonna let you know also. Excuse us a moment. When that sound came on, she had her weapon. She was trying to keep me safe. I'm just letting you know. Hey. I'll show you the video. Court does call the case People versus Victor Bullard. Are you ready on that?
Yes, Your Honor. The victim has arrived. Absolutely, for the people. This is the public defender Natalie Pate with on behalf of Mr. Bullard, who is approaching. May we approach?
You may. The exam, because it should be quicker and then go into the exam. So just to let you know where the court's gonna head, but I'll stand in recess and just let my staff know when you're ready. Ms.
Thank you.
Court's in recess. All rise.
State of Michigan is now back in session. We are on today's Cedric Simpson.
You may be seated. Court does call the case, People versus Victor Bullard.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate, working on behalf of Mr. Victor Bullard, who stands to my right. Please state your name for the record, sir.
Victor Bullard.
Thank you, sir. All right. Date and time set for trial. Are we ready to proceed?
People are ready to proceed. We would move for sequestration. I'll note for the record, my officer in charge is sitting at the table with me, but I only have one anticipated witness who is currently on the program.
All right. Court would grant the motion to sequester. Are there any potential witnesses for the defense other than the defendant?
No, Your Honor.
All right, very good. That is satisfied. You may go ahead.
Thank you, Your Honor. With defense's consent, I'd also waive opening at this time.
Any objection?
No objection, Your Honor, and defense would also be waiving opening at this.
All right, fantastic. Thank you.
Ajane Bullard.
All right.
She stepped out for the moment, Your Honor.
Say she stepped out.
Restroom, Your Honor.
Got it.
Yeah,
Got it.
yes, both for me.
Got it. Please come forward and be sworn.
See, raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
See, state and spell your first and last name for the record, please.
AJANAEBULLARD.
And that's Ajane Bullard? Yes, thank you. Inquire.
Ajane, do you have a nickname you go by?
Yes.
What's that?
Asia.
Okay. Is it okay if I call you Asia? Asia, we are making a recording, so when we say things like, they don't really come through on the recording, so we may ask you just to confirm if your answer is yes or no, okay? Asia, how old are you?
17.
And how old were you on May the 12th, 2024?
15.
Where do you live?
4695 Ashford.
Do you know what township that's in?
Pittsfield.
And what county? Okay. Your Honor, would the court take judicial notice that Pittsfield Township is in Washtenaw County?
Yes. Court will take that judicial notice.
Thank you. Do you know somebody by the name of Victor Bullard?
Yeah.
Who's that?
My dad.
And do you see your dad in the courtroom today?
Yeah.
Can you tell me where he's sitting and what he's wearing?
Wearing a gray suit.
And where is he sitting?
He's sitting right
Your Honor, may the record reflect witness to identify the defendant?
Without objection, record shall so reflect.
Asia, on May 12th, 2024, were you at your house? And what was going on that day when you got up?
So it started out normal. We do chores every Sunday.
That was a Sunday?
Yeah.
All right. What happened when you were doing your chores?
So my chores clean the bathroom. That's what I did. And so my dad was gonna leave to go to his mom's
Why was he going to his mom's on that day?
because it was Mother's Day.
And when your dad was going to leave, what happened?
We got into an argument because I had asked my TV back because he was going to be gone for more than a day. So I had asked for that.
Had your TV been taken away?
Yeah.
What TV was this?
My TV.
Where, it's in your room? Who bought it?
My mom.
Why did you want your TV back?
Because I had it for like months and months and months.
What did you want to do with it that day?
We were just gonna be home alone, so like, I wanted to do
Who's we?
me and my siblings.
Where was your mom?
She was doing errands.
Does she live at that house too? Was she there when your dad was getting ready to go to his mom's house? Do you know where she was at that time? What happened after you asked for your TV back?
It's escalated.
What do you mean it escalated?
We started arguing because we didn't agree on the reasoning why I got it taken.
And who is we?
Me and my dad.
You started arguing. What happened next?
He was downstairs and I was upstairs and we were like arguing in the stairs. And it was like half of the stairs and he was yelling at me and
What was he saying?
it was just like we were just arguing about the reason why I just didn't have it.
What happened as you was going up and down the stairs?
He just looked mad and he looked angry.
What happened next?
Then he went back downstairs and then he started back up the stairs. And then he came all the way up the stairs this time, like to where I was. And then he just started yelling at my face
Where were you when that was happening?
right up in my room.
You have your own room?
Yeah.
It's on the second floor?
Yeah.
So you got in your face. What happened next?
I had like, he was like so close to me, like he was like a couple inches away and I was scared because I could feel him spitting my face. He was way taller than me, he's bigger than me, and I knew he had a gun on him. And
You knew he what?
he had a gun on him.
Okay.
Um,
Where was the gun?
and
In his pants? What happened after he got in your face yelling at you outside of your room?
he told me to go to my room. And so.
Did you?
Yeah, I quickly turned because I was scared. Because, you know, it wasn't like the first time. Like, he had gotten that like that.
So when you went in your room, what happened?
Then he quickly chased after me. And he grabbed me and he scratched my head.
Where did he grab you?
He grabbed my arms. Both of them.
What happened next?
I said, why are you trying to hurt me? And then he left.
Did you end up calling the police?
Yeah.
And Your Honor, at this time, I'd like to admit into evidence what I'm going to mark as People's Exhibit 1, which is the 911 call. I believe it will be stipulated.
That is correct, Your Honor. I did talk to Ms. Lonnie.
All right.
Right.
Exhibit 1, the 911 call is admitted.
Permission to play for the court?
Yes.
Washington on 911, where is your emergency?
Hi, my name is Asia Bullard, and I'm at 4695 Ash Court. I'm calling because my dad did an animal case, and he was yelling at me.
Okay, what's the address?
4695 Ash Court.
Is that ASH?
Yeah.
Okay, and you're in Pittsfield?
Yeah.
Okay, how old are you?
That's 15.
When did it happen?
So it's just now.
What's his name?
Victor Boyer.
How do you spell last name?
Bullard.
Spell his name.
I think he's like 54.
Okay. And what kind of vehicle do you live in?
He left it.
What color? What was your name?
Asia Bullard.
What's your phone number, Asia?
734-596-1647.
Okay. So you said he hit you? What did he do exactly?
He grabbed my arm, scratched me on my neck.
This is about a argument?
Yeah.
Okay. Do you live there with him?
Yeah.
Okay. Then you live there with anybody else?
Yeah. Pretty good.
Are they home?
My mom was someone taking us to the airport and my other sibling at home, she said he's an adult. So she
Okay. Okay. All right. Any weapons used or involved?
he had a gun in his hair, like,
Did he have it out also?
no.
Is it still on him?
I think so.
Is it in a holster?
I'm not sure.
Okay, when you say he had it in his pants, did it have like in a pocket, was it clipped on?
I think it was like in his hand, my hand.
Okay, okay, all right. Do you need any medical attention?
No.
Was he drinking or under the influence of any narcotics you're aware of? Okay. All right, well, let's someone come over and talk to you, okay? If he comes back or if there's any other issues before we get there, call us back, all right?
Okay.
All right, thank you.
All right, bye.
Bye-bye.
Asia, you mentioned that some of your siblings were home when this happened. Is that right?
Yeah.
Did you have a chance to review a video that one of your siblings made?
Yeah.
And that video, Your Honor, for this time, I'd ask permission to enter People's Exhibit 2, which is the video from the sibling. I believe it will be entered by stipulation as well.
That is correct, Your Honor.
All right. Exhibit 2 is admitted.
And Asia, when you reviewed this video, it didn't show anything, correct? But what did it have on it that was relevant to what happened that day?
The audio of the incident.
The audio of it? Okay. You have permission to do,
Yes.
sorry, Your Honor, it clipped the beginning a little bit. I'm gonna go back. Apologize. Asia, did the police come to your house on that day? Did you talk to them?
Yeah.
Did they take any pictures of you? What did they take pictures of, if you remember?
They took a picture of my scratch and with my door.
Why did they take a picture of the door? Had it been broken before? A little bit? And you're under permission to approach the witness and the bench with what's been marked as Exhibit 3.
Is there going to be any objection to Exhibit 3?
It's multiple pages. There are 3 pages for Exhibit 3.
Your Honor, at this time, I am going to object to part of Exhibit 3 that does have multiple photos. I do not believe a foundation has been laid.
Well, before you go on with that, there are 3 pages. Are you objecting to all 3 pages or?
No, Your Honor, I would not be objecting to the first 3 photographs that are shown in this exhibit.
Okay,
So the
I haven't
first-
seen it, so.
Yes, the first page and a half, I would have no objection to. The last page and a half, I would, Your Honor.
It's not making much sense to me. How many photos are on each page?
2, Your Honor. And I object to the first or the last 3 photos.
So I have a total of 6 photos.
Correct, Your Honor.
First 3 photos you have no objection to.
Correct.
The last 3 photos you do have an objection to. And the basis for your objection is,
Lack of foundation. I believe that this may be rectified if these were 2 separate exhibits. They do have photographs of 2 separate things.
response.
Your Honor, the witness has stated that her door got more broken in this incident. Part of People's Proposed Exhibit 3 is photographs of the door taken by Pittsfield upon their response. I believe that if there are questions about how broken the door was, if it was broken at a later time, at an earlier time, those can be ample grounds for cross-examination, but I do believe the foundation is sufficient for the admission.
The basis for the objection.
The basis for the objection, Your Honor, is that the last 3 photographs are photos of the door, and the testimony from the witness was that the door definitely was broken before. And I do not recall any
Well,
testimony.
that wouldn't go to its admissibility. It would go to the weight to be given to the testimony. So objections overruled. Exhibit is admitted.
Okay, here. Permission to approach still?
Yes.
Thank you. Copy for the correspondence. Asia, do you see People's Exhibit 3 in front of you? What do you recognize that first picture on Exhibit 3 to be, the top one? That's the scratch on your neck? Who caused that scratch? Did you scratch yourself to do that? How about the second picture? Can we go to the next page, page 2 of Exhibit 3? The top picture, what do you recognize that to be? Same scratch, of course. And the second photograph on page 2? How do you know that's your door? How was it broken before this incident?
It was like, this is a little, it was like a little dented, but it's not bigger.
How did it get more broken?
My dad pushed.
Is that when he pushed in and went in your room?
Yeah.
And let's go to the last page. What do you see in the top picture there? How do you know that's your door? Do you recognize that?
Yeah.
When your dad pushed into your room, was he able to open the door all the way?
No.
How come?
There was stuff.
Is that in any of the pictures on page 3?
Yeah.
What's behind the door that was in the way? And that last picture that also shows the broken door?
Yeah.
Okay, you can stop looking at those now if you don't want to look at them anymore. Asia, how did you feel when your dad grabbed your arms and scratched your neck? Was he giving you any commands or any orders that you were disobeying at that time? Let me ask a better question. Was he disciplining you?
Yeah.
How?
He was mad. I was, talking back.
He was mad that you were talking back, so he broke in your room and yelled at you and grabbed your arms and scratched you?
Yeah.
Was he, after this happened, did he stay? Where did he go?
He left.
He left his mom's house. And when you were at your house and the police came, was your mom there at any point?
No.
She came later. Asia, did you do this to yourself, the scratch mark? May I have a moment, Your Honor?
Yeah.
I'll pass the witness, Your Honor.
Cross-examination.
Hi, my name is Natalie and I'm an attorney for Mr. Bullard, so I have some questions to ask you. And I know I used to hate it when people would call me Miss Pate, still kind of do. Would you prefer for me to call you Miss Bullard or Ajane or Asia? Asia, okay, thank you. You feel free to call me Natalie. So I just have a few questions to ask you to follow up on your testimony. If at any point my questions are either unclear or I'm mumbling, feel free to interrupt me and tell me to either rephrase, re-ask, whatever the case may be. So I'll turn right to the day of May 12th, 2024. You testified that you were 15 at the time of this incident?
Yeah.
And you and your dad before this day previously had some disagreements about some of his rules, correct?
Yeah.
You didn't like some of his rules surrounding when you could or couldn't use your TV?
Yeah.
And you didn't like some of his rules about when you could or couldn't go out and see your friends, right?
Yeah.
And you feel that sometimes your dad's a bit hard on you?
Yeah.
And then turning to the incident, you told the police that this interaction with your dad began that day in a verbal argument, right?
Yeah.
About his rules regarding that specific TV?
Yeah.
And you were mad that he wouldn't let you continue to have it in your room? And you did tell the police when they arrived that your dad did not threaten you at any time during this argument, correct? And you told
What was your answer to that? You don't know?
Wait, can you ask that?
you told the police that your dad did not threaten you at any time during this argument, correct? You told the police that your dad tried to grab you, correct?
Yes, he did.
And you told the police that your 3 siblings were present during this incident, correct?
Yeah.
But none of them saw anything?
No, and very.
And you were the person who called the police that day, correct?
Yeah.
And that was at the encouragement of your older brother?
Yeah, he said it to do if I felt unsafe in my house.
That what?
He told me to do if I felt unsafe in my house.
But your dad had already left the house that day, correct?
Yes.
How old is your older brother at the time?
23.
Does he live there?
No.
Was he there?
Yes, he came after my sister showed the video.
After what?
He came after my sister showed me the video, and I called him because I was scared.
So he wasn't, so the first call you made was not to 911?
No,
The first call you made was to whom?
my brother.
And that was after he had received information, you believe, from someone else? Your sister?
What do you mean?
Well, one of your siblings sent the video that we saw. I think it's Exhibit 2, right?
Yeah, he didn't see that till he got there.
Okay, so prior to him, so your brother appeared after you called.
He was there while I was calling them,
Well, while you were calling who?
the police.
Okay, but you called him first,
Yeah,
and that's why he came over.
yeah,
Okay, go ahead, Ms. P.
And your dad had already left the house at that time, correct?
yeah,
And when the police arrived, you declined medical attention, correct?
yeah,
And you knew that you could possibly get your dad in trouble by calling the police that day, correct?
yeah,
And you were pretty upset with him that day?
yeah.
And so now I have a couple of little odd questions. You typically do your nails, correct?
Yeah.
And you often wear them pretty long, correct?
Yeah,
Including fake nails or acrylics.
yeah,
And you often style your own hair as well?
yeah.
And then I have a couple follow-up questions about your testimony. So are you aware that your dad is a valid CPL holder? And you testified that he grabbed your arms, correct?
Yeah.
You did not testify that at any point he grabbed your neck, correct?
Yeah.
And you also testified that this door definitely was broken or damaged in some way before this incident, correct?
Yeah.
You're not listed on the title to the house, correct?
Yeah.
If you know, who is on the title to this house?
My dad.
So the owner of the door would be your father, correct? The door is not your personal property, correct?
No.
Okay. No further questions. Thank you. Thank you, Your Honor.
Did you have any follow-ups?
No,
I said
no.
you do. The TV was in your room?
Yeah,
How, and at some point, it gets removed from your room.
yeah.
How long before May 12th was it removed from your room?
A lot of months.
Pardon?
It was months.
Months?
I think it was close to a year.
A year? So why did it get removed from your room?
Because I had it on past 12.
Because you had it on past 12?
Yeah.
So was it a rule in your house that you weren't supposed to be watching it after midnight?
It was more like, it just like, so my TV goes off by itself.
Pardon?
My TV goes off by itself after like a couple hours of activity. He got said that it would like run while sleeping for a little bit. And
Okay.
so he said I had on past 12 and then he,
So young lady, let me ask you this. Was there a rule in your house that you weren't supposed to have the TV on after 12?
yeah,
Okay. And at some point, it was on after 12, regardless of the reason, it was on after 12.
Yeah.
And so from that, the TV got removed from your room.
Yeah.
Okay. And was that removed from your room by your dad?
Yeah.
Okay. In this, let me ask you this. So you knew what your dad's position on that was, right? Without telling me what you said, did you go to your mother about that?
Yeah.
Did your mother put the TV back in?
No, she couldn't, she didn't have access to get it.
Okay. So this day, May 12th, a year, I guess, after the TV's been removed or whatever. What were you and your dad specifically fighting about?
Like, what do you mean?
Well, something caused the argument between the two of you. What was the cause of the argument?
Because he was leaving and I had asked my TV back.
Okay, so hold on. Those are sort of two things. Were you upset that he was leaving?
No,
Okay, were you upset at that point that you didn't have your TV?
yeah, and the reason that he was saying, because he kept adding on reasons like all the time, like it wasn't like the original reason that he took it.
There was no reason for what?
Like he, like was saying the reason that he took it was a different reason than what he said originally, and that's what we were arguing about as well.
Okay, so just help me understand this. At some point, the TV gets removed from your room because it's on after midnight. Then at some point, I'm going to assume that this May 12th date was not the first time that you asked for your TV back.
Yeah.
And if I'm understanding you correctly, the times that you would ask, your dad would give you different reasons as to why the TV didn't come back in.
Yeah.
Okay. And when he would give you these other reasons as to why you couldn't have the TV, was that upsetting to you? Okay. Just as a side note, was that the only TV in the house?
No.
So then this day you want the TV back, and what's your dad's response to that?
He said no.
Okay. And I'm going to assume you didn't like that answer. Is that correct?
Yeah.
Okay. And so when your dad said no, what did you then do?
I asked why.
Okay. And then he responded back to your why, right? What did he say?
He said because like I was like hanging out with my friend. It wasn't supposed to be.
Okay. So when you asked why, he said, and tell me if I'm wrong, because I'm trying to understand what you're telling me. He said it was also because you were hanging out with somebody that he did not want you hanging out with. Who was that? Don't give me a last name. Who was your friend?
It was just my friend.
Okay, I get that. Who was your friend? Name.
His name is Dwight.
Okay, so, pardon?
We just went to the park.
Was there a reason your dad didn't like this friend?
No.
Well, hold on. Let me rephrase that. Why do you think your dad didn't like that friend?
I think he didn't like him because he's a guy, but that's my little sister, he's no guy, so.
Okay, hold on a second. Hold on a second. So at the time you're 15 and your dad has told you not to hang out with this young man.
After.
Well, hold on. He had told you not to do that, right?
After the fact,
After what fact?
after everything else.
Okay. Okay. So at some point you're hanging out with this young man, right? Then your dad says, I don't want you hanging out with him. It's a yes?
Yeah.
And when your dad said that, how'd that make you feel?
They make me feel really excluded.
It didn't make you feel any way?
It just like, it felt like unfair.
Oh, okay, so it was unfair. So when he said, now I'm going back to May 12th. So when he, being your father, said, because you were hanging out with this person, what was your feeling?
I just felt like it was unfair because he let my sister do stuff like that and like hang out.
How old is your sister?
She was, I think she was like 11 at the time.
Okay. So she was 11 at the time and she was hanging around boys?
Yeah.
Okay, but you felt it was unfair that your dad wasn't letting you hang around boys?
Yeah.
So after your dad told you not to hang out with this boy, did you hang out with him? You didn't?
Not after that.
Not after that?
Not after the police got called and stuff.
Okay, hold on a second. Let's back up. At some point, your dad tells you not to hang out with this young man.
Yeah.
Okay. After that point, but before this May 12th day, did you hang out with that young man? Do you recall the date your dad told you not to hang out with that young man?
No, I don't.
But it was before May 12th? Okay. So between the time of that and the incident on May 12th, where you called the police, did you hang out with that young man?
Again.
Yeah. So when your dad told you not to hang out with him, you stopped?
Yeah.
Did you tell your dad that on that date? On the May 12th, when he said it was because you were hanging out with this guy?
Yeah, I think so.
What do you mean you think so?
Cause I think I said like, I hadn't hung out with him.
What was your dad's, if you said that, what was your dad's response to
He
that?
said that's the limit, so that's why. He said he wants to talk about it when he got back from his mom's.
So he said he wanted to talk about it after that?
Yeah, after he got back.
What?
After he got back from his mom's, he said he would talk to me about it later.
Okay, so at the point he tells you about this young man on the May 12th, at some point, he then tells you, basically, I'm going someplace, but we will talk about it later.
Yeah.
Did that upset you? Okay, so I hear, when I listen to the video, I hear, no, that's you yelling back at your dad, right?
Yeah.
What were you yelling back at him about?
I was asking for my TV because basically I was paying a subscription. And I'm just going to like,
You were what?
I was paying for a subscription for my Xbox and it was going for like a long time. I haven't had my TV in a while. And so I was upset that I was also paying money and I couldn't even.
So were you working at the time?
No.
Okay. So you had a subscription. Were you paying it?
Yeah.
From where?
I was like, I just asked my mom for money
Okay, so, all right.
or like went and worked like by doing like little side hustles, like babysitting. So my money was very like, I didn't like have a lot of things.
Right, but. Got it. I won't get into that. So at some point, your dad's leaving, you're there are words being exchanged. Where are you when this argument takes place? Is your room upstairs or on, okay. So where are you guys downstairs when it first happens?
No, I was in my room.
Pardon?
I was in my room and he was like going up and down the stairs, getting ready to go to the mom's.
Okay,
But I like stayed in my room the whole time.
you did not.
I stayed in my room the whole time besides when I went to the hallway.
Okay. When you went to the hallway, you and your dad are yelling at each other?
Yeah, he was like on the stairs and then we went downstairs and then he ran up the stairs halfway because our stairs like.
Okay, so when he went downstairs, what do you think caused him to come back upstairs?
Maybe didn't like something he heard and that made him.
Okay, you didn't like what he heard. So what was he hearing?
Just arguing about,
What were you saying, young lady?
I don't remember exactly.
Okay, let me ask you this. You don't remember specifically what you were saying?
Yeah.
Were you saying things that maybe your dad thought were disrespectful?
I don't think necessarily.
Okay. Were you saying things to your dad that you knew would get his attention?
I think I was saying what I felt and how in my truth.
Okay. But you also knew, correct me if I'm wrong, you can tell me I'm wrong. You knew that as you were saying those things about how you felt in your truth, you knew that was not going to sit well with your dad.
Yeah, he doesn't like anyone that disagrees with him.
So at the time that you're saying those things, you knew that was going to get a reaction.
Not like that.
Well, didn't ask that. You knew that was going to get a reaction.
Somewhat.
And that's when he came back upstairs.
I didn't do it for reaction. I did it for.
I didn't ask you why you did it. I'm saying you knew it was going to get a reaction of some type, whether what your motivation was. You knew it was going to get some reaction, right? And then at that point, that's when he came back upstairs. Okay. So how did he arrive at your door?
So after he went upstairs, he went back down and then he started back up again all the way to my door.
Okay, so when he went back down and then you say he darted back up, did you say anything at that point?
Yeah.
What did you say?
When he was at my door.
No,
or when-
something caused him to come back up. Did you say something and then he came back up?
We were just continuing arguing. So.
What were you saying during that argument?
I don't remember.
You don't remember. You can remember everything he said, but you can't remember what you were saying?
No, I just remember like in general what it was about.
And what was it about that you were telling him?
I was just like why can't I have my TV back? It's been a long time and that I don't hang out with that guy anymore. And it's unfair that you let my little sister that's younger than me, and I'm about to turn 16 in like a few weeks, and she can do what I can't.
But those are all things you said before, right?
Yeah, just like, it was like a continuing argument.
Okay, were you yelling?
I was like talking normally at first and then
At the point, okay, let me be specific. At the point he went back downstairs before he, as you say, darted back up, were you yelling?
I don't think,
You don't think you were yelling?
I think maybe like slightly raised, but I don't think-
Slightly raised, but not yelling. Okay. And then he got back up the stairs and he's at your door.
Yeah.
So when you're at your door, or you're in your room at that point.
I was, when he came up the stairs, I was in the hallway.
Okay. So he comes up the stairway, you're in the hallway. So when he comes up the stairway, there's a landing, I presume, or the hallway.
Yeah.
Right? When he gets to that landing, where are you?
I'm
You're in front of your door. Okay. And I'm presuming that the two of you are still engaged or talking or yelling at each other.
Yeah.
Right?
Yeah.
Then at some point, you what, go in your room?
he had told me to go to my room.
What?
He had told me to go to my room.
He told you to go to your room.
Yeah, like right in front of my face.
Pardon?
When he was like right in front of my face.
He told you to go to your room.
Yeah, and then I turned.
At the point he tells you to go to your room, had he laid a hand on you?
No, but he looked like he was.
Didn't ask that. He hadn't laid a hand on you. When your father told you to go to your room, did you go right to your room?
Yeah, I turned really quick and I went to my room. I didn't touch him or anything. I was too scared, so.
So when he told you to go into your room, you went into your room. What's the next thing you did at that point?
So I went to my room and then he chased in right after me. And I tried to close the door because he like, it just scared me. And,
Did you get the door shut? Did you get the door shut?
no, not fully. My door didn't latch closed, so.
So young lady, I'm trying to figure out. I'm looking at. I want to show you, and counsel, I'm referring her to page 3 of exhibit 3. I want to show, oh, you got it. Okay, you got one in front of you. Look at page 3. Right? I see a latch missing.
Yeah.
You see that?
Yeah.
So if you're, again, I'm going based on what you're telling me. If your dad is at the door, you're trying to close the door, but it doesn't close. How'd that latch get damaged?
I had my sibling had done it a while ago.
Okay, so the latch isn't in the door.
Yeah.
Okay, so looking at that, tell me what damage your dad did to the door, I'll call it, on that day.
It's the big like in
The big indent.
Yeah.
What big indent?
like the part where the door is like broken, like on the like actually.
Point at it for me. Oh, on the front of the actual door. So the latch, he didn't break.
Yeah.
And counsel, she's pointing to, I guess it would be page 2. The
Photo
circle.
4, Your Honor.
Pardon?
Photograph 4 of exhibit.
Yeah, I guess we can call it that. And so it's that little crevice in the door. How do you think he did that? He's obviously on the other side, right? So how do you think he did that?
Well, because I was on the other side of the room, I was trying to hold it shut with my body weight and he was.
So let me get this right. He's on one side of the door, may have some part of his body on the front part of that door. Because it's what's called a hollow core door. So he's on that one side. You're actually pushing on the back side of that door.
Yeah.
So it's not like he kicked the door. He's just against the door.
Yeah, he's pushing it like his whole.
So wouldn't you agree that both of you caused the damage? Because hang on, and here's the reason I'm asking. If you're not pushing on the one side of the door, but he's just pushing on the side he's on, according to you, that damage doesn't happen, right? Because he's just able to come right in.
I mean, like, what do you mean?
The only way that door gets damaged on that side or at all is because there are two forces pushing on that door. Your dad from the outside and you from the inside, right? So it's not like he came up to the door, he kicked it, or it was locked and he kicked it to get in or anything along those lines. Okay. So he gets into, so at some point, does he get into the room?
Yeah,
At the point that he gets into the room, what's happening at that point? Are you still yelling at him? Or are you guys yelling at each other, I should say?
well, I was, he like grabbed me. You know, I said, why are you trying to hurt me? Because he was obviously like he was trying to do something. And
What do you mean he was trying to do something?
like, I feel like he was trying to hurt me.
Really?
Yeah.
So let me ask you this. I'm looking at your dad and I looked at you walk up. And lady, if your dad really wanted to hurt you, he could have hurt you. Right?
Yeah.
That's not what happened. Right?
What do you think?
I think you know what I mean. If your dad really wanted to hurt you, he could have hurt you.
Yeah.
And that didn't happen.
I mean, it did hurt. He looked like he was like trying to do something.
What?
It looked like he was trying to do something. It looked like he just like couldn't control himself.
What do you think he was trying to do?
I think that he was trying to like grab me and like do something, but I didn't let him. I said, why are you trying to hurt me?
Why were you yelling at your dad?
Because he was yelling at me first.
When he told you to go into your room, how'd that make you feel?
Almost. I mean, I was scared, so I just did it. I didn't say anything. I just turned to him there.
But how'd you feel when he told you that? Hmm?
Like I don't know.
Let me ask you this. Are you the oldest daughter?
Yeah, perhaps.
Yeah. And because kids think this way. Did you think maybe your dad or maybe your parents both were showing your younger sister a little bit more favoritism than you? Yeah. Yeah. And that hurts, doesn't it? Yeah, it does. And sometimes you kind of want to let them know that, right?
Yeah.
I mean, you want to let them know that I feel like I'm not being treated fairly.
Yeah.
You and your dad fight a lot.
Yeah, we argue.
Yeah. Um, you're 15 at the time, right?
Yeah.
Your sister's 11. Yeah. You seem like a pretty bright young lady.
Yeah.
Whether it be right or wrong, can you think of any reason why your dad might be a little bit more suspect or careful about boys you're hanging out with as opposed to your sister?
Maybe because they're older.
Mm, and what's that mean?
I don't know.
Yes, you do.
I-
That's okay. You don't have to say it. You know, right?
It was just my friend.
I get that. That's what you're telling your dad, right?
But she was also hanging out.
Hold on a second. That's what you're telling your dad.
Yeah.
When you would tell your dad that, and I'm not only a judge, I'm a dad too. So when you're telling your dad that, do you think your dad believes you?
Hmm?
That he's just a friend?
Um,
No, hold on. I'm not saying what you think. I'm saying when you tell your dad that, do you think your dad believes that?
I don't know.
You don't know?
No.
Do you think he's a little bit suspicious about that?
Yeah.
Yeah. Probably mad about that too.
And my sister hanging out with guys that are 3 years older. So it's like,
It's not fair, right?
yeah.
Yeah, hard question, young lady. Well, let me ask this one before I ask the really hard one. Why do you think you and your dad argue?
Because I'm a lot like my mom.
You think it's because you like your mom? You don't think you argue because you might be like him a little bit? No? Out of all the things that are unfair as you see them, out of all of that, do you think your dad does any of this because he hates you?
No,
Yeah. Why do you think he does it?
I think there's some resentment.
Of you?
Yeah.
Oh, so your dad has resentment of a 15-year-old. Tell me how that works.
I think that he has resentment of my mom.
Pardon?
I think he has resentment of my mom. And I'm a lot like her. And It's always treating.
So you think he's taking out whatever his feelings may be for your mom on you? Really? Let me ask you this, young lady. In looking back on it, looking at it that day, do you think your dad was trying to hurt you?
Yeah,
You do?
yeah.
Let me ask it this way. Do you think on that date he was physically trying to hurt you?
I don't think,
Or, hang on. Was he physically trying, do you think he was physically trying to hurt you? Or maybe doing things that hurt your feelings?
I think they was trying to hurt me.
Physically hurt you?
I think that's where it got, but yeah. It's not that way.
Young lady, when the whole thing started with the TV that day, you two were just going at it, right? And then it kind of just was taking off from there between the two of you, right?
Yeah.
Because sometimes that's what dads and daughters do, right? Yeah. Okay. Any questions based on the court?
Yes, Your Honor.
Go ahead.
Keisha, I want to ask you a little bit of context about your home and your parents. I know some of these questions are really personal and uncomfortable, and I'm sorry. Do your mom and your dad stay in the same bedroom?
No.
They have their own rooms?
Yeah.
Does your dad keep his room locked?
Yeah.
Where was your TV when it got taken away?
No.
Have your mom and your dad stayed in separate rooms for a long time?
Yeah.
Years? Do you hate your dad? How do you feel about him?
I love him, just disagree about it.
Nothing further.
You have no questions, do you, Ms. Faye?
No, Your Honor.
Thank you.
Do a motion appropriate though, Your Honor.
Pardon?
Oh, sorry, Your Honor. Never mind. Straight that correct.
You may step down. Okay, thank you. Any additional witnesses or the people?
No, Your Honor. People rest.
And Your Honor, I do have a brief motion for a directed verdict as to both counts, specifically as to count 2, viewed in light most favorable to the non-moving party. The people have not introduced sufficient evidence for a reasonable fact finder to find my client guilty of the count of malicious destruction of personal property. Witness did testify that the property in question, the door, was not for personal property. Therefore, frankly, the elements have not been met, and I would ask the courts to find a directed finding of not guilty as to count 2. As to count 1, I also would posit to the court that the people have not found or laid out sufficient evidence for the trier of fact to turn a verdict guilty beyond a reasonable doubt. As to count 1, as to my client, Mr. Bullard, would ask the court to also find a directed verdict as to count 1.
count two, I don't know if it never got communicated, we weren't intending on pursuing count two. That was because it was joint property between the defendant as well as his wife, Ms. Bullard. That was no longer going to be pursued. I apologize that it didn't get amended on the
That
information.
I don't think was communicated.
I apologize.
All
So
right.
that one I'm not pursuing, so that is completely valid and a good directed verdict motion, and I will concede that. As to count two, I think with the testimony in light most favorable to the people, a reasonable fact finder could conclude that we have met the burden, and leave it there.
As to count two, I will grant basically by stipulation as to count two, the malicious destruction of property. The court reviewing the defendant's motion could reserve its ruling, but rather than reserve its ruling is to count one, the child abuse. In the evidence look in favor, most favorable to the non-moving party, that being the state of Michigan. The court disagrees with defense and does conclude that a reasonable fact finder could conclude, if the witness is believed, that the defendant would be guilty of child abuse in the 4th degree, and so therefore will deny the defendant's motion. Prior to closing, the court's going to take about a 5-minute recess. I'll come back. We'll hear closing.
Mr. Johnson was
He did
pro
enough
se.
damage.
I think
for
Mr.
you to
Johnson
have to
changed his
repair.
mind at the last minute.
But, what was that case about? So,
He was helping somebody move, got kidnapped, taken somewhere. They beat him up, tied him to a stripper pole, stabbed him a few times.
how could I forget?
Right.
So it's not really surprising you would have handled that one. I know, but he's fixing the mess now, what he's doing. Okay, but now we get, it's always been a concern, the older cases, but now with the way things are, and hey, I mean, they've now become pecuniary about all of this in the judicial system. Anything over 1,000 days gets scrutiny, and it ought to. But I can only try one at a time. But this is 1,200. This is far older than most cases.
And I appreciate that, Your Honor. I'm not going
So what are you going to do about it?
Well,
Look, when can you be wrong?
if I can get discovery, which I don't anticipate being too big of a problem, we will give like 30, 45 days. I imagine. Just need to get him signed in as a lawyer. Get you discovery.
There's a lot of nice letters.
Oh, yeah.
That he wrote, he's a steady, most of this is his letters, that really are, there's nothing that much, nothing really I can do to react to those letters, except try to get something him. He's so old, and if it were me, I'd be upset, but can you be ready in 4 weeks? Have you talked to him today about it?
I've not talked to him today, Dave.
Ask him, what are you thinking otherwise? I mean, it's not like you're gonna have to dig up everything. This stuff's just sitting in there.
Yes.
You can look at that file.
Did you, from the difficulty of the client, upon like 6 weeks, give him a couple extra? I think I wouldn't object to that. Give me 6 weeks, I'll do it.
Fine. Okay, Daryl Johnson, then we'll set that. the trial in 6 weeks, but please be ready.
Understood.
All right. Did you get everything in the file?
Okay, that's about awesome.
Oh, no, we said, I get this thing in on July 17th. You just came in 4 days ago. Did you just like, you filed something 4 days?
Yes, yeah.
And
And I think you filed a motion this.
But tell him that you're on it and we'll specially set it, okay?
Yes, sir.
Yeah, here in about 6 weeks. Let me know if that's a problem.
Yes, sir.
Because when we specially set.
We'll knock it out.
Yes, sir. Okay.
Thank you.
Serafel Simon, Serafel Solomon.
I'm assigned to this case. It's indicated as pro se.
Yeah, it's another 1,231 day old case.
I would
Old,
like to reconfirm with the defendant whether or not he still wants to represent himself. So we need to
let's see what the most.
ensure that he's got all this discovery.
What's his Nope.
Stand over there and just find out.
May 16th.
So
On behalf of Mr. Bullard, who is present.
I don't think I formally asked you, are there any witnesses for the defense?
No, Your Honor, I did discuss this again with my client and he did, and I advised him of his absence to testify on his own behalf or to remain silent. And at this time, I will not be calling him or anyone else as a witness.
Very good. Closing arguments.
Your Honor, viewing the evidence in light most favorable to the people, excuse me, the people do believe we've sustained our burden and ask to return a verdict on single count of child abuse. Otherwise, I will rest on the proofs. Thank you, Your Honor.
Closing.
Thank you, Your Honor. So we're here today because of a father setting some ground rules for some of his teenage children and trying to enforce them. We've all here been teenagers before, myself not too long ago, if dare I say it, and we've all had arguments with our
You're
parents.
saying that's in the,
Pardon me, Your
you're
Honor?
saying that because why? You want to
I have
compare that to when I was last a teenager?
probably.
Never mind, Miss Tate, go on.
And so, as Your Honor was also a teenager not too long ago as well. Maybe even at the same time, but I do not know that. I've had arguments with my parents over rules they've set over the years. I believe many people, it's a common human experience. We've heard the testimony today that Miss Bullard wanted her TV back, and my client wasn't going to give it back for whatever reasons. I'm not going to comment on anyone's parenting, whether or not a teenager has a right to a TV, whether they do not, whether they have a right to go to their friends or not. My client was just setting some ground rules for his minor children that they happen to disagree with. They did have a verbal argument. And I will agree that they did have a verbal argument that day regarding the rules. However, my client never intentionally laid his hands on Ms. Bullard in any way. We did hear the testimony, and Ms. Bullard testified to the fact that Mr. Bullard grabbed her arms. I am not stating that that happened or did not. What I will say is that she did not at any point testify that Mr. Bullard touched her neck in any way. She did not testify that he grabbed her neck, that he tried to grab her neck, that he touched it, even in passing. There was no testimony or evidence presented that he purposely or intentionally touched her neck or caused that scratch on her neck. Candidly, because we did see a photo of a scratch on Ms. Bullard's neck, I will acquiesce that she had one on that day, and that picture was taken by the police. We don't know how we got it, or how she got it. Candidly, I don't know how grabbing of the arms could lead to that stretch on the neck. My client is not guilty of this offense of child abuse in the 4th degree. He is the parent or guardian of Miss Aisha Bullard. He did have care custody of her that day. He did not knowing intentionally harm her, injure her, or put her in a position where at which she could be harmed. They did have a verbal argument. She was angry about that. When she talked to her older brother later that day, as Ms. Bullard testified, he encouraged her to call the police, which is what she did. When the police arrived, she declined medical attention. And Mr. Bullard was not there at that time. We don't know what investigation the police did to get his side of the story. That was not presented today. I'm asking the court to return a verdict of not guilty, as the people have failed to meet their burden that my client intentionally harmed Ms. Bullard in any way or caused that injury to her neck. Thank you, Your Honor.
And just briefly in rebuttal, one thing, I do think that Ms. Asia did state that the defendant scratched her as seen in Exhibit 3. And I do ask the court return the verdict of guilty. Thank you.
In this case, and I will refer to her as Asia because that's how she wanted me to be referred to. I listened very closely to her testimony in this case. Surprisingly, well, not, I won't say surprising. She was very candid in her answers. I'm not sure entirely, also, as I'm looking at her and listening to her testify. I feel bad for her. And I feel bad for her because, quite frankly, I think I haven't heard from Mr. Bullard, or I haven't heard from Mom either. But I think both of them are failing her. And I say that because I think it's an interesting thing about kids. All they want to do is be loved. That's really all they want. And I think she's, frankly, as I understand the circumstance, being forced into a circumstance, regrettably, to choose sides, and she doesn't know why. Some of the unfairness that she talks about is that there's that unfairness of some young man who is just a friend, and I can only imagine what that's all about. Probably not necessarily the reality from either perspective, but dads sometimes react that way with their daughters. You know, young lady, one thing that you're going to have to kind of get used to regarding anyone that you bring into your life is, and I'm sure it's going to happen, same thing with Mom. You're going to see them. They're going to see them. They're going to make an immediate assessment. And then that's where it is. They're going to have to either prove themselves worthy or not. It's just life. But on this day, and I asked some very specific questions of Asia, and I do appreciate her honest answers and appreciate at the end that she didn't hate her father. There are probably things that are going on in that household, things in the world she doesn't quite understand. You know, she's only 16, so the only world she experiences is what's around her. Sometimes also the argument that parents and kids are having isn't really about what it is. That sometimes happens with all human beings. It's probably about something much deeper. But as you listen to Asia, she was talking. Dad says X. She wants something else to happen. They begin yelling at each other. And as they begin yelling at each other, it begins to just sort of escalate. Asia said it best herself. When I asked, do you think your dad was trying to hurt you? And she said that he wasn't, that they were yelling at each other. But the one thing that she then pointed out was it got to where it got to. Don't think when you got to that doorway, it almost becomes this showdown at the door with both sides not wanting the other to win or leave with the upper hand. Sometimes when you have a child that is trying to say something, whether screaming, yelling, doing whatever, because I guess the big people in the room, one has to sort of step back, kind of realize, or kind of try to figure out what it's all about. Dad said something that was interesting, but that wasn't satisfactory to Asia, especially about the boy and about everything else. That he was going to come back, he was going to see his mother, he was going to come back, and he was going to talk to her. On the surface, that seems kind of reasonable. And I guess if one were second guessing, maybe there should have been a great pause and saying, maybe I need to talk with you now instead of going. Because maybe that's what my child needs. I'm not going to sit there and second guess it. There. Sometimes that's what has to happen. I also don't think, well, Asia did what she did. I don't think really Asia relished the fact of having to sit here and try to testify against her dad. I don't think she liked it. I don't think she should, where one can help but be there in that circumstance. Say this. Just gonna say it may be inappropriate. Mom and Dad, you've got to do better. You just have to do better. You have a wonderful, beautiful daughter that was up here testifying, and the two of you have to do better. She should never think, either because it's true or either because it's something placed in her head, that the reason Dad is so hard on me is because I'm like Mom. First of all, I've never seen a child that is just one parent. Never seen it in my life, and doubt I ever will. They're part of both of you. And both of you need to acknowledge that she has those parts. Part of that yelling going back and forth between daughter and dad was because they probably are a lot more alike than they want to even acknowledge at times. She was going to try to give as good as she was trying to give, and that was just going to go. And then it was a point at which who's going to win or try to win. You guys have to do better. If it's true that Dad treats her a certain way because you're like Mom, well, that's something Dad has to get over and realize that's his little girl regardless. If that's not the case, but something being planted because of the dysfunctional dynamic that may be going on in that home, planted in her head by Mom, and Mom, you have to let that go. You two don't have to like each other, but you gotta love that little girl. Both of you. Prove this charge of child abuse 4th degree, and I'll just skip to the elements. Clearly had custody or control. But the defendant knowingly or intentionally committed an act that under the circumstances posed an unreasonable risk of harm to the child, or did something in a reckless fashion that caused that to the child. I don't believe that people have sustained their burden of showing that by any stretch of the imagination. I don't believe that, based upon the testimony before me, that the defendant's conduct was by any means reckless. And by her own testimony, Asia admitted that the acts in and of themselves were intentional in terms of what was going on. Now, to the extent also that one might believe that they were intentional acts, the concept of parental discipline, that parents are certainly allowed to discipline their children within reasonable limits. Given the circumstances as described by Asia, the force on the door, I noticed that while there may have been a mark to the neck, I'm not thoroughly convinced that that came from the actions of Dad, and certainly not any intentional act. The one thing that was missing, which would have seemed to have been there had he been in just this rage of anger, would have certainly been marks to her arms. I have no proof of that because she's very clear that he grabbed her arm. And if that was his first grab, there certainly would have been marks, bruises, something there when the police arrived. Given all of the circumstances and the totality of the circumstances, it's not up to the defendant to prove that his acts were reasonable, but more for the people to show that his acts were not reasonable. The people have not met their burden in that respect regarding the actions of the defendant on that day, ultimately ending up at the door. Asia's pushing on one side, Dad's pushing on another side of the door. I think that there might be differences in that, but it certainly wasn't shown to the court that this was not an exercise in a certain respect of parental discipline with no intent by her own statement that this defendant was intending to harm. And so for those reasons, the court would find that the people have not sustained their burden, find the defendant not guilty of count one child abuse in 4th degree.
Thank you, Your Honor.
Thank you. Thank you.
Thank you. Thank you.
Asia, do me a favor. Take care of yourself, young lady. Got a lot going for you. Okay? Take care. For a standing brief recess, we'll get set up for the.
It's our courtroom.
Okay, Solomon, we need Mr. Solomon, please. Surafel. Bless.
He intends to continue pro se. I just want to do something
Have you
to ensure that it's
stood by
not
in
all
the past?
discovery.
I don't know. I'm on the, when I pull up my docket online, I'm tagged to this case. So I'll assume that means it's not the point that asked if it wouldn't be in the 6 second.
Standby counsel.
That's what I thought. That's what I said. It's not showing. It's showing up as per se, not showing up on my printout of my case.
Yes, it says John West standby.
Okay, that's what I thought. I just want to make sure that's what.
It was wrong.
Make sure he's gotten discovery or?
Yes. There's about 30.
30 of them.
Just, it's something we need to handle before the morning's out, Judge.
Sir?
I'm asking that we
They're bringing them over.
deal with that before the morning's out.
Deal with what? There were
Two issues, whether or not he wants to continue pro se. Two is whether or not he's received all discovery.
It's 1,231 days. He should have. Huh?
He should have, but I don't want to go on should. I want to make sure.
While we are waiting, I have Brandon Kirksey with Mr. Wilkerson. Where are you? Not here.
Mr. Wilkerson's office sent something that said he had a protective order in another court, Judge.
Which court would that be?
I don't remember. I
Can
think
you-
I printed out.
You are Mr. Solomon. Yeah, no, find out what that is. I never do protective orders. I mean, who
Yeah,
does that?
give me a
Who
minute,
does
Judge. I can
protective
print it out.
orders? So that nobody else has a fair chance at
It's not,
disposing of the case?
it's not uncommon,
I
Judge.
know it's not. But it is to me. And it's uncommon to me.
Yeah.
600 jury trials. Who does that? Other than me. I mean,
They're just
I
trying
think
to.
it's a conspiracy to keep me from getting a 700.
I think all the judges are working against you.
Ooh, good point.
We do have a,
How about the defense attorneys? What's the word on that? How many are working against me on that? Other than Ryan Kenyon.
Say the same thing I write about it. I don't know.
I don't know. He's been the lead.
I've heard the phrase 599 or bust.
All right, Mr. Solomon, this has been a while. What are we going to do about resolving this, right? It needs to end, don't you think? Yeah. Okay. Do you still want to represent yourself? Or have you thought about it? Are you able to hire somebody financially? If you're not, we can appoint someone, you know that. You've certainly had to think about it. It's 1,235 days old. It's 4 years old. What do you want to do on that? No answer? Sir?
So,
Any answers? We got to move on here. Yeah. Okay. All right. You need some answers here, right? And these are important questions. You've had 4 years to think about it. But do you want to continue to represent yourself? That's the first thing. Or if you're unable to hire an attorney, a competent attorney would be appointed to represent you, which, there's an old saying that a person who tries to represent themselves have actually a fool for a client. But I've seen people do well. And it's there, and the law says they can do that. But I've seldom ever in my career seen someone represent themselves and do outstanding. It just doesn't compete with the rules of evidence and lawyers who have been to law school. But what do you want to do?
I initially hired a lawyer. I'm trying to recoup my money and hopefully I can maybe hire another lawyer.
Okay. If you're unable to hire somebody, I'll appoint someone. These are all competent lawyers who are on the list. What do you want to do?
I don't understand why my lawyer dropped off my case.
But you had hired him?
I hired him.
Well, there's really, who was it?
Mr. Simpson.
He didn't even talk to you about it?
No.
Did you fail to pay him? Is that what happened?
I believe that was the motion to withdraw. Yes,
Well,
we had a few disagreements. Those definitely balance still owed, but
okay, this says There's a motion to withdraw that was filed back on January of last year and a half ago. Says he was retained by you. Good cause exists for withdrawal. Mr. Solomon was late to court on January 29th, tested positive for drugs, has not lived up to his obligations to the law firm contract. It is not sought for delay, but this withdrawal is sought that justice is served. So that's where that was.
My memory is, Judge, that you had a conversation with Mr. Solomon at that hearing, and it was after that that he was moved to the pro se representation and you appointed standby counsel.
That was John West.
Yes, Your Honor.
All right. Well, we're going to move forward one way or the other. If the attorney can't get retained, then Mr. West is going to represent you. Or if you don't want him to represent you, he'll be appointed standby, which is awkward. But that means if he's standby, you're a grown up, so you get to make a choice. And if you don't know the rules of evidence thoroughly, you didn't go to law school, you haven't tried cases as a lawyer, you're at a disadvantage because you will be treated as though, as the other lawyers are, to know the rules and know the law. And it doesn't, 45 years in this. And jurors don't feel sorry for folks who are not representing themselves in a professional fashion. That's the way it looks. So that's why it's important you get somebody to at least be near you. If you want to try it on your own, it has in 45 years been an absolute failure. But we're grown-ups and you're a grown-up and you can make your own choice. But it's a bad idea. And and if you don't want him to help you, he'll stand by and he'll be next to you. And if you ever need to get advice, but still it is awkward and it doesn't impress jurors. So, that enough to think about? You have to speak out, sir, please.
I'm digesting everything you're saying.
I have to have a response from you. What do you want to do? I got a million things today, and I got to pick a jury here in a little bit on another case. And you've had, this is 1,200.
I haven't even met the lawyer. We've never spoke. I would say, give me a chance.
Y'all gonna go talk to us.
Yeah, I just go over the case, maybe, have an understanding.
Look, I'm gonna reset this for 2 weeks, okay?
3 weeks.
3 weeks. I'm gonna reset it for 3 weeks. Yeah, but y'all talk today.
I've never met him.
Okay.
First time.
I'm gonna release.
Thank you.
Yes, sir. John, I'll release.
Kevin Hall, Tom Burbank. There's these other two cases.
We both do it before marriage. This is you might have felt something. Yeah, but it's not good. I understand. I'm just saying. It looks like I'm going to tell you that
Judges, when they want those protective orders, then.
With me?
Not you, no, but I get something today on a protection order, for today.
From Harlem County?
Yeah, he talked to him, yeah.
Orange County. It's laughable, but we got other things we can do. It's just, I don't, if that's gonna happen, you don't alert people on the day that everybody has to be curious for you said, all of a sudden, and what makes, why don't, here's what happens. Everybody files a protective order and then what, against each other on the same day, what happens then? If I was an administrative judge, I'd find that less than amusing to have to come in and preside over someone. Maybe that only sign. I'm thinking of it. All right, I'm sorry. On Kevin Hall. Really? What we're looking at this.
After the mistrial, Judge, Matuska, I came in after Mr. Matuska.
Yeah.
They hired me for some reason.
We got 3 cases here, right?
He does.
Well, one of them looks like it's in
This is
enhanced, a 3rd degree enhanced, 2nd degree. No, that's 2nd degree enhanced to a 1st on possession.
Right.
So that's 1 first. 3rd degree is enhanced to a 2nd in the unlawful possession of the firearm.
And then he's got the aggravated robbery
And
that's
then
also enhanced.
The aggravated robbery with two aggravated robbery fires. So it's enhanced to a 15. Well, I guess the aggravated robberies are the ones that are going to be the ones that are most focused. What do you think?
You took me the last week. I just needed a little bit. I could.
How much? Well, 3 weeks, 4.
Oh, that's fine.
All right.
There's some things I need to address in reference to Discover.
Just going to have to be trying, I think. Okay. What's again?
His co-defendant was found guilty, but
Yeah, what did you say, 32 years?
yes, 32.
I don't want to even think about it because they're not to make. There's an instruction. Don't flip a coin.
I wish I had 32.
Okay, Eric Renfro, Sean. Where?
He might have college there.
Eric Renfro, and well, let's make sure. Yeah. How long would it take? How long do you think this one would take?
I mean, showing less than I see on Sherry. Not at least.
Stand by, please. Just
Cheers, 35, never change them.
What are we looking at, Judge? What are we looking at?
Right, 10 minutes. Yeah.
Wasn't me.
We gotta be made that Sunday.
Yeah. That's all. Henry knows. Probably say 15. I'll probably total. Out there. Well, what's this mean? I'll trust you. Messing with me? No, I'm not. I trust you. Said that. No. What do you got that one? I don't come back from didn't pick it up. We're gonna get several emails. I didn't see you do that in my places. Why did they address you? I say, oh, for like, okay, I don't.
Okay, that's, I want to just check about this. I thought it was. How old was the child?
What does the indictment
15
say?
or 16? It says younger than 17.
I believe the child was 15.
I believe it's probation, so you're working out 14 or under. Right. Yeah, probation's not eligible. They're not, that's what I was looking at.
No, he's eligible for probation.
All right, so y'all ready?
Yes, Your Honor.
Okay. Kenneth, Jackson? Kenneth Jackson, Mr. Burbank?
He's in custody. We want ready to know that Mr. Eckhart is going to be occupied
Is he?
somewhere in the file or somewhere. He's been in custody for almost 4 years.
Why?
And
We just trying to
he
think.
can't make bond.
But is everybody ready to go forward there?
We're ready. But I understand Mr. Eckhart.
I am ready though.
He's ready. Okay.
And so I was wondering, maybe if we can't do it today, maybe sometime this week in the morning, we can address maybe a bond. No reduction on the bond.
All right.
Should I get a hold of your office?
Wednesday. Wednesday. We'll just reset it to Wednesday.
Wednesday morning, 9 o'clock.
Okay, thanks.
Thank you, Ron.
Alexander Benevamonde. Alexander Benevamonde.
Defense counsel's, conveying a new offer to his client outside, Judge.
Okay, he's here.
Yes, sir, they're both outside.
And Anthony Woodruff. Mr. Benavides.
His attorney has called me probably a dozen times to tell me that he is trying a jail case in Harris County this week and he has a protective order and he's not sure, but he did tell his client to be here, is what he told me.
His office as well for the client to be.
He's freaking out.
Who is?
The attorney, because he doesn't want to, be in contempt of your orders, but he's got to be in Harris County is what he said. But his client should be here, is what he told me.
Well, lost it. I don't see the file.
There should be two of them.
Benavides, huh? No,
No, that's the.
that's the one.
That's the lawyer.
It's Woodruff. I got Woodruff.
The wrong name.
2 cases.
So in light of that, I would suggest we just make sure his client's here and go from there.
I never do protective orders.
I know.
45 years. And
Everyone else loves him.
it's just,
But I will credit him that he did try out in advance to let you know.
Anthony Woodruff. Anthony Woodruff. No answer in the courtroom. I ask the bailiff to call into the hall for Anthony Woodruff, please. Get nothing done on this.
I just haven't had time to really talk with anybody or look at anything on this one.
Interesting. There's no response to that name being called into the hall, no response to the name being called here in the courtroom. Defendant's bonds are revoked, warrants are issued for his arrest, no bonds since these are the trial docket. Thank you. Kobe Rogers, Brian. So. Yes, sir.
Bridget.
Oh, okay. God, what the aggravated sexual assaults we have on Docket? Huh?
There's a few, Judge. And
Good try. I
don't think I can.
Andrew Kennedy's next, and that with Mr. Reynolds, and that's the same thing.
I don't believe I have enough time in this.
Today to try all of them this week?
Well, no, I'm gonna make my announcement per case. I don't believe there's enough time with the courts available trial time this week to try.
I don't even have time to try the one that's 2 weeks old we're in the middle of right now. I don't know what I'm gonna do with that. What are we gonna do, buddy, on this? Still try it, right?
He wants to trial.
Okay. I regret I have but one body to give to my county. Travis Jackson. John West. Yeah, John.
Ready, Your Honor.
So this gets tried? This is a trial?
Yes, Your Honor, but it's also the first case that says these.
Well, I know, but I mean, this stuff never gets tried. This kind of stuff. All right.
I know.
Okay. All right.
We didn't think we'd ever get tried.
Well, let's just.
He has enhancements. I don't know if he's habitual or not. And the other one wasn't there?
Oh, he's an habitual felon.
Yeah, I think that's the issue, Judge.
Well, the issue comes to a head sooner or later.
It does.
Yeah. Okay. See what I can do. Jamichael Phillips. David Grove.
He's here, Judge. We talked briefly, but that is.
Does anybody know where Mr. Grove is?
The back.
Can we find out what he's doing? And then Joseph Lighton, that's yours.
Great.
What are you doing there with that?
He's another gal, he was talking to.
Okay.
Docket from a couple of weeks ago, Carol, plead that thing.
Mr. Phillips, it is one that
Lighten,
could potentially try with the time.
Let's Lighten, he's here, right? That's good, you can see that.
David, on Jamichael Phillips.
Yes, sir.
Y'all ready?
Well, he doesn't want
Yes
to
or
take
no?
the deal. He doesn't want to take the deal.
Oh, y'all-
Another lawyer, but
Y'all are ready.
besides that, I
Okay.
think we're
All right.
probably ready, but he asked me to tell him before that.
But he's in jail. But that's still.
Yeah, that's actually preferred when people are in
All right, we're
jail.
gonna send this one to drug court
Okay.
trial. Okay.
Yeah, I just spoke to the judge.
And otherwise, it's our hearing come back.
Jury for tonight.
No, jury it was.
Oh, it's tomorrow morning.
Okay. Well, but I don't, there's that was fine. I say, I'm sending him, you guys still are.
They have their.
Okay. Kathy, you're. No, we didn't. Okay, let's get to our 9:30 document. We're sending one case over to drug impact with Mr. Grove's client, and the rest get resettings because I'll be back in trial tomorrow morning. And we don't have any other. All the other judges seem to be busy.
I'm got another course, so.
So that's what happens. Okay, Crystal Anderson.
There's still trying to, there's something we're trying to correct on that from a previous sentence. I'm still trying to figure out.
9:30s.
If we could just have a few minutes on.
Okay, where's Langston? Is he?
I think he's in the.
He's here. We signed her up, but I don't know if we signed her up correctly or not. I gotta check.
Andrew Diaz is his case too on that. So that's Sonny Eckert, who's not around. Then I've got James Robertson. James Robertson. Langston. Where's yours? Hey, on Crystal Anderson and James Robertson.
Langston, before we do Chris Anderson, I need to make sure we got right this time because we messed up on the previous plea and I need to make sure it's right this time too. So if you just give me just a few minutes. I think I might have made another mistake. I don't want to screw it up.
No, we'll make it work. We'll make it work.
What are we gonna do on James Robertson?
I was asking if we could have just one reset on him to another announcement, not a trial, just announcement. We're trying to make that one happen. And I think on
How much time?
4 weeks work for you?
Yeah.
4 weeks fine.
All right, James Robertson reset for 4 weeks at request.
I just asked just to.
Yeah, it's solid.
Yeah.
Matthew Leonard, Don.
Ready, he's Dusty signed up.
Come on up. Thank you. Okay.
And Anderson is a sweet. Matthew Leonard.
I need.
Have everything all.
You want all
that.
stats?
Thanks.
Yes, sir.
Yeah, 3 cases on Matthew Leonard. I know you're need his friend.
Yeah, I don't even have them in my queue. I'm trying to sign that. Okay.
All 3?
Yes.
Okay.
One of them's gonna be dismissed.
Which one?
The state felony. That's 23/18/46. No, sir, she's gonna need to get your fingerprint from that or.
This perhaps.
I'm You're fine. But letter, please raise your right hand, swear or affirm. Self you got it?
Yes.
And you get your right thumbprint? Right there? Place it right there. You can go on top, not the same one, yeah.
You dropped the phone.
Yeah, thank you. You can go stand for me on the judge, right?
Your full name, sir?
Matthew Lewis Leonard.
Mr. Leonard, I've got 3 cases here. It looks like one of them is to be dismissed. And you've got these 2 others, 23 CR 1845, first degree felony of fraudulent use or possession of identifying information. And then 24 CR 166, second degree felony of illegal possession of methamphetamine. And we're going to take these 2 up. It looks like the third one is cause number 23 CR 1846, state jail felony of unauthorized use of a vehicle. That is to be dismissed.
Yes.
All right, does the defendant waive formal readings of these indictments and these arraignments here? Can we proceed in summary?
Yes, sir, we can.
In summary, 23 CR 1845 alleges that on or about August 18th, 2023, 2 years ago, August 18th, 2023, in Jefferson County, Texas, you committed the first degree felony of fraudulent use or possession of identifying information Do you understand what you're charged with?
Yes.
If convicted of a first-degree felony, you face a term of life imprisonment or any term of not more than 99 years or less than 25, or less than 5 years in prison. And in addition, a fine may be assessed not to exceed $10,000. Do you understand all of that?
Yes.
An agreement has been reached in this case.
Oh. And a bunch of state jail. No, well, this one was added as a state jail.
You would be pleading guilty, sentenced to 10 years in prison.
Jimmy gave an offer.
And then this will run concurrently with the illegal possession of a controlled substance 166 case we're going to do next. And then 1846 is to be dismissed. Is that your understanding of the agreement?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes. The only question I would have,
Go ahead.
would be about the credit.
We'll take that up last. It's in the computer and she's figuring it up. Like during the course of a plea, she figures it up to tell you.
Understood.
Nobody knows better than you. How do you plead then to this first degree felony of fraudulent use or possession of identifying information? These are 50 items or more, which makes it the most serious first degree felony. Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty of this?
Yes.
Yeah. Sorry.
Okay, we're going to now put that one aside for a moment, go back, go to 24 CR 166, and thus the defendant waive a formal reading of this. Can we proceed in summary?
Yes.
In summary, this indictment alleges that on or about August 17th, 2023, in Jefferson County, Texas, you committed the second degree felony of illegal possession of methamphetamine, controlled substance. Do you understand what you're charged with here?
Yes.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement has been reached in this case. You would be pleading guilty, sentenced to 10 years in prison to run concurrently with that preceding case. And again, a third case will be dismissed. Is that your understanding of the plan?
Yes.
If I follow this, you have no right of appeal of your cases. Do you understand?
Yes.
And how do you plead to this case? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
Yes.
I show you what's marked on each case, what's called State's Exhibit 1 up at the top. Did you sign that document voluntarily, understand it, discuss it with your attorney? Or the contents in each case true and correct?
Yes.
State's Exhibit 1 is tendered into evidence, and without objection, it is admitted. Among other things, this states you were mentally competent to enter your guilty plea, and it is freely and voluntarily made. You know what you've been charged with. The indictment's been written. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true at stake, so help you God. Exhibit 1 has made a part of the record for all purposes. Let me just show you something that kind of bothers me a little bit. Look at your signature on that's at the top and it's at the bottom. It looks like two different signatures. Is that the way you sign your name?
Yeah, well, just because I was handcuffed and it was just tough.
Okay. Yeah. Sometimes it looks awkward because of that. I understand. But and look at this one. That's a third different one. I mean, that's.
Yeah, I was just. Yeah.
I mean, they all look different, and I mean real different.
I did sign this.
Okay. Pre-sentence reports, when it is. If nothing further, I'm going to follow these agreements. and find in 23 CR 1845 and 166 the first degree felony of fraudulent use or possession of identified information and the second degree felony of illegal possession of a controlled substance respectively in these two indictments. You, Mr. Leonard, are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 to find you guilty beyond a reasonable doubt. So, and I now find you guilty beyond a reasonable doubt in each of these cases. I'm following these agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. These sentences going to total. You will be given credit for all time you have served. We calculate that later on today. And if there's a problem, you let somebody there know, but you never do have a problem. Okay. And there's a dismissal on that one?
Yes.
And Matthew Leonard, cause number 1846. Before the court. Sarah, when did you sign this motion to dismiss?
Today, did I put the wrong date? How badly did I mess up the date?
30 days. You put 6/21. That was a good month, though. That was the day after my birthday. Then the first day of summer is 6/21. So.
Right hand, we're at war. You get one more time. We have to take those. Yes.
Terrell Johnson. David, what are we doing on Terrell Johnson? That says a plea hearing. Terrell Johnson.
Judge, I need to
look into it. Kyle Mulholland. Look into that one.
Yes, sir.
Taylor Sedlacek. 2 cases, 3 cases, 4 cases, 5 cases.
Judge, last time we had a docket call, he rejected plea agreement, and I thought the judge appointed him other counsel. Not sure an individual, but he has 7 cases.
Judge, he said that he was thinking about the plea and you gave him a week to think about it, to come back.
Oh.
If he didn't want to take the plea, then.
Oh, okay. Yeah, that sounds like
I'll talk to the judge then.
Derek Shepard. Elizabeth Stout. Brittany Sylvester. William Weston.
Would you rest question is what
Asia Young. Those are all on the docket. Okay, look into those, please.
Yes, sir.
Ashley Nelson, Benjamin Jeffries, Mr. Jeffries. Yeah. It's an announcement. What are we doing on them?
On Ashley Nelson, we are looking at my motion for competence.
I don't think you have that, Judge. I think I have it. Okay.
Yeah, David's 20 cases.
Yeah.
Okay, Mr. Jeffrey, I'm looking at this and all this is conclusory. I mean, I was told it once a long time ago, I never, by the judge, and then I realize now why that happened. I used to do it and I didn't understand. I said, all you had to do is put a conclusion. But it says, you believe the defendant may suffer from mental impairment. That doesn't matter. And it's been disclosed past MHMR diagnosis, which could leave her incapable of, those are, that's a maybe, a possible, that doesn't get it. That doesn't cross the line. And that can be used in every case. That's why that door doesn't get open. It's got to be something more specific than that to trigger an evaluation, because maybes, both of these are a could. One is could and one is may. We need to know actually what is actually happening here and what are the manifestations that you recognize from your experience and training.
Yes.
That needs to be done. But that doesn't.
Would you like me
It's
to elaborate on that one?
Not really. I'd rather get in writing that's specific. How long have you dealt with this person?
A matter of weeks.
Weeks. Okay. How many times have you talked to him? You just have
3.
Okay. What's happening?
She's hearing voices. She says
That's what she says.
schizophrenic.
No, when you ask her a question.
So when you ask her a question,
did
it's
she
just,
say, this is my name and I'm a girl?
she knows her name. She knows she's a girl. She
Okay.
recognized me as counsel. She understands she has a legal issue. She's not able to voice how this legal issue actually came about or give any.
Let me ask this. What do you know about past diagnosis of mental issues or past rehabilitation?
Only what she has disclosed.
Okay. Where did that happen? Here?
Where did she disclose it?
No. Where would she have gone to mental health?
In the Beaumont area.
Okay. Have you looked into that?
No.
Yeah, that's what we need. Medical records will help.
Okay.
If you can get those before we start.
We'll
Trying to, we went 3 years in law school, right? They didn't do a lot of psychiatric work with us and tell us how to do this, but that's why we refer to them for their medical, and that's going to be the triggers. What did they analyze her and what did they come up with? Because you and I aren't going to go in there and say, yeah, we're medical psychiatrists and here we are. We're going to make a determination. I need, the data.
That's what I was hoping the court would assign a medical professional to do such.
If you'd be so kind to get on her behalf those records to me and put them, of course, in a sealed method, and then that'll really be 90% of the work that we need to do. Otherwise, I don't want to hear it where I'm going to be asking her questions because the patient is not going to be the best determiner of what the medical evaluation and treatment was.
We'll get that.
Thanks. That's all for it. How much time?
Hopefully I can knock that out in a week or 2.
Oh, okay. 3 weeks. Yes, 3 good. Okay. Yes, sir. Thanks.
And I believe that concludes all my actions.
All right. Right, Katie Knight.
I didn't talk to Sarah about this.
Well, then I guess it's 1 hour into the docket. It's never too late. Thanks for invigorating. Katie Knight. You were a Boy Scout, weren't you? Didn't you go to Boy Scouts? They threw you out of Boy Scouts. Caleb Landry. Sir?
Asked to resign.
Oh, you don't want to represent him anymore?
No, Boy Scouts.
Oh, no, I'm talking about Caleb.
Like he signed it.
All right, Caleb Landry. Need Caleb Landry. We signed up.
Yeah.
Let's do the plea. Thank you. Two cases, right? Two cases. While we were waiting, I've got Deontay Batiste. But is that Mr. Walker's case? Those two have been reset, correct? Odwin
Yes. that's-
and Lane Walker, is that right?
Right. That's what it said.
They've been reset. John West on Christopher Chambliss. What are you gonna do on Chambliss?
She said that for, medical records.
Is that right?
Should be evaluated. That's why it needs to be evaluated.
Wait, so what are you doing? Is there an order of evaluation?
It says reset for Dr. Eval.
Is there anything I need to follow up with and sign?
If there is, I'll get it checked out.
Yeah, because I don't prepare those generally. Those get prepared for me.
We'll follow up on that.
Yeah, let's don't lollygag on it. Okay. That's an NPRP too?
Yes, entropy and
Daniel Jenkins.
That one also said reset for Dr. Eval.
this is gonna be, this is a much of a, actually, we're gonna have to sit down.
What is?
Somebody for information.
Raise your right hand, swear or affirm to tell the truth.
Did she just say something about an evaluation on that one too?
Pick up your right thumb.
I don't think there's evaluation on that one.
I thought she just said that.
Oh, I don't
Right
know.
there. That's what my docket says, but I didn't write that.
I don't know about that. That's not.
Can y'all check for sure so we don't set something for a hearing?
Yeah, I
Need
had
something else?
I didn't have it over there.
Yeah, I'll check on a judge.
Otherwise,
We'll say-
we set for NPRP.
Yeah, set it for the area and some kind of.
Gaddafi Johnson.
That one, Your Honor, we said, last time I was here, that we set it for the trial, and there are a lot of. He wants to try, so.
Justin Manning.
Dr. Johnson, yeah, trial. But Justin Manuel, Your Honor, still working on that one. That's kind of a newer one.
Keto means, what do you want on manual? 3 weeks?
Well, let's go 4 weeks. Let's
4 weeks on manual, please. Keto means,
set down for trial. That's a trial into that. I don't know, that's on this topic. Yeah.
we'll talk. We got to bring those people out though, and
That's not
sure that that's
Anybody-
it's their word. Taviante Fontenot is no attorney, no offense. Okay. You are, sir? Oh.
Two stages.
Getting muted?
Got it.
Twenty-three CR 908 and 24 CR 2225 are both called. The state of Texas versus Caleb Landry. That's you, sir? Mr. President, but Mr. Kimler, you were attorney and the state's attorney does the different way. Formal readings of these indictments and the arraignments here. Can we proceed in Sunday?
You guys were right.
In summary, 908 alleges that on or about February 14th, 2023 in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you are charged with? Yes, sir. If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand? An agreement's been reached. In your case, you would be pleading guilty and you would be confined and safe. Can I put 1 year on that
Yes.
instead of 12 months? Okay. You'd be sentenced to 1 year in the state jail to run concurrently with this 2225 burglary of a building we're going to be going into next. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily on your own free will and because you are guilty?
Yes, sir.
I want to hold that in suspense for a moment and then go to the next case, 2225. And You waive a reading, formal reading of this indictments, and we can proceed in summary here. In summary, paragraph 1 alleges that on or about September 17th, 2024 in Jefferson County, Texas, you committed the state jail felony of burglary of a building. And we have 2 other paragraphs. We are passing on those prior convictions.
Yes, sir, we are.
Is that right?
Yes, Your Honor.
Yeah, we're only going in paragraph 1. So again, this is another state jail felony, same punishment range. You face a term not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. And an agreement's been reached where you would be pleading guilty, sentenced to just 12 months, 1 year in the state jail to run concurrently with the preceding case. Is that right? If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this case, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily in each of these cases and because you are guilty?
Yes, sir.
And in each of these cases, I'm showing you what's marked as State's Exhibit 1. Did you sign those documents voluntarily? Understand them, discuss them with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
No objection.
without objection in each case admitted. Among other things, these state that you are mentally competent to enter your guilty plea is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crimes charged in each case and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your attorney. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 in each case tendered and without objection admitted. Correct.
Correct.
All right. Pre-sentence reports waived.
So,
I'm going to follow these agreements, if nothing further. I'm going to find Mr. Landry in each of these cases. You have pleaded guilty voluntarily to these state jail felonies of burglaries and building in each case.
Okay.
You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted in each of these plea papers here in each hearing to support your guilty plea, to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. Each of these burglaries of building state jail felonies. I'm following these agreements. You are hereby sentenced to confine in the state jail for 1 year in each case. These run concurrently. Do you understand what's happened today?
Yes, sir.
Anything else?
that
That is all. Thank you.
it's just a reminder, there's a plea on your tablet off the file document.
I have 2 cases, a Crystal Anderson and a Alexander son of a Monday.
Alexandra,
Say.
Try that again. No, don't even look. No, I just want to hear you. Do it.
Bit of a Monday. That's the best shot I got, Judge. Feel like I used up all my words last week.
That's your best shot?
That's it.
Is it? Okay.
Sorry, that's what you get.
Sorry to hear that. Do you have it over there?
What do you asking? What do you asking? So about the I'm not agreeing. If you ask him, it's gonna come back. Yeah, I was gonna ask you. If she's gonna, if that's it, hold up, then it stays in the file back. I'm not done. If you understand.
Is it? So here it is.
That is the dismissal on the other 2 we just did. And we now call post number 23 CR 0002, the state of Texas versus Alexandra Ray Benavimonde. I got this. I'm going to do this. Benavimonde. Right. And you were here with your attorney and the state's attorney. Does the defendant And you're Mr. Cavada.
Yes, sir.
Does the defendant waive a formal reading of the indictment and the arraignment queue? Can we proceed in summary?
Yes.
And you speak fluent English and Spanish. Yes, ma'am. In summary, this indictment alleges that on or about December 25th, Christmas Day, 2022, in Jefferson County, Texas, you committed the second degree felony of aggravated assault with a deadly weapon on the birthday of our Savior, Christmas Day, where we're supposed to be happy and gifting each other and praising
They were celebrating.
good things.
They were celebrating.
Too much. And let's see, you threw a bottle, caused bodily injury by throwing a bottle to the victim, striking her in the face. And thus you used a deadly weapon, namely a glass bottle, that in the manner of its use and intended use is capable of causing serious bodily injury or death during the commission of the assault. Anything can be used as a deadly weapon if it's capable of causing serious bodily injury or death, which a glass bottle is. On Christmas Day. I hope that's an aberration, right? That won't happen again, right? I mean, we're celebrating a special day.
She has no history, Judge.
I'm literally speaking on that. With that statement.
She has, she has no criminal history and the state has offered to move this as a class A. Lesser included offense, dropping the deadly weapon accusations.
Okay. There's a plan here. This is normally a second degree felony that would carry with it up to 20 years in prison, which you would have had to, if you were sentenced to 20 years in prison on that, you'd have to serve half of it, because if a deadly weapon is used, you have to serve 50%. That would be 10 years, 3,650 days, which goes slowly. An agreement has, however, been reached where you would be pleading guilty to the lesser included Class A misdemeanor of assault, which carries with it up to 1 year in the county jail and or a fine up to $4,000, right?
That's correct. Yes, sir.
An agreement's further been reached here where you would be pleading guilty, placed on deferred or unadjudicated probation for 2 years, fined $500. There would be terms and conditions of probation, which are normal and customary. And there's some good things about maybe we need just something to remind us to be composed in times of stress. We've got programs that would help with that. Is that your understanding of the agreement?
Yes, sir.
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
Is this checked? It's a plea bargain case, but the trial court has given permission to appeal?
I tried to erase that, Judge. It's,
Okay, I've erased it.
thank you.
I've never done that.
That's why I
I don't know
initialed,
why or whatever.
that's why I initialed the top one.
We move along, and unless there's something, I would think there would be something technical to appeal in a 1 in a million cases that we dispose of by plea agreements, but the 99.99999% of all cases was not even considered because it's generally there's no valid reason for it. But I could see where it could be in a very rare case. This doesn't seem to fit that. So you've waived your right of appeal. If I follow this, and I'm going to follow this agreement. How do you plead to this charge, ma'am? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily on your own free will and because you are guilty? Yes, sir. I show you what's marked as State's Exhibit 1. Did you sign that document? Understand it, discuss it with your attorney, or the contents altered and incorrect?
Yes, sir.
All right, State's Exhibit 1 is tendered into evidence without objection. Admitted. You've never been in trouble before, have you? No. This is fixable. We're going to fix this. We're paying us for the most part. Among other things, this states you are mentally competent to enter your guilty plea, which is freely and voluntarily. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime and any lesser included offenses like this assault. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this states is true, so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived. Correct.
Yes.
It's waived. Pre-sentence report is waived. We're going to move forward today. And the quicker you get on it, the quicker it ends. If nothing further, I'm going to find you were pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. But I'm not going to do that so long as you follow the terms and conditions of probation. You will be placed on deferred or unadjudicated probation for 2 years. You do well, it can be shortened in 1/3 at that time, which is, as we know, as early as 8 months.
Yes.
It will be terms and conditions of probation, which are normal and customary for this. Was there any restitution here? Anybody? Who's Jimmy?
Sir.
Was there any restitution on this?
No.
Okay.
No known restitution, Judge.
Nobody was injured, huh?
Somebody was injured, but there's no.
They didn't
known
go to the
restitution.
hospital and they didn't claim damages.
They haven't claimed anything, Judge.
All right. There will be terms and conditions of probation, which are normal and customary. One of these will include to complete an anger management program, which was actually a really good program that maybe everyone in the world ought to take. From time to time, we lose our composure, do something that we regret, and that makes us human and imperfect. But we just try, and we don't want to do it again. Please see the probation officer and do well, okay? Thank you, ma'am.
No big deal.
Yes, sir.
Thank you.
So, which is fine, but we don't.
Crystal Anderson? No, I want to save the county money. Crystal Anderson?
We're ready.
Is she in custody?
Or
she-
she's in custody.
Oh, okay. Crystal Anderson, please. Where's that one? Do I have it in my little?
No, I got it. Judge, this is one where she was sentenced before, but the sentence was incorrect, so we bring her back to,
Sentence was incorrect.
it was.
How did I do that? 1 year in the state jail, 3rd-degree felony? That obviously is not right.
Just need to send a transfer from last week.
Langston Adams?
We're ready, Your Honor.
Judge, this is a case we've got to correct. Because when the motion was filed, it was filed as a state jail felony because there were a bunch of state jail felony, a couple of other state jail felonies that she pled to at the time. And I was out of town, we didn't catch it. And so it's really a 3rd degree. So we need to amend the motion to say 3rd degree felony, and then we're sentencing her to 2 years pen time. She's agreed to sign an agreement. So we're just correcting what we did wrong on. So.
Okay, this judgment was done though on March 19th, right?
Yes, sir.
I can correct things in 30 days. I don't know if I can do it.
Well, it's an illegal sentence because it was
I know, but.
So we can't do it.
There probably needs to be some paperwork that reflects like a motion for new trial or something like that that needs to be in the file, or else it just doesn't, there's not a connection with everything.
Well, can Langston just ask for a new trial and I have no objection right now?
But
And
there needs to be something in writing in the file somehow that reflects. And that's what you're asking for, because is that right? Because it's an illegal sentence.
correct.
That sounds terrible, but it inured to her benefit. And she was placed on
Given 1 year state jail,
deferred, I'm sorry, she was placed,
10/10.
it was a third degree felony from the outset.
Yes, sir.
And she was sentenced about 2 years ago
Yes, sir.
for, is sentenced to 10 years in prison. That was suspended and she was placed on regular probation for 10 years. I signed the order on placing on probation, regular probation for 10.
Yes, sir. When I signed a couple of documents, I missed the state jail on that. And so I was out of town whenever it came up and somebody else took the plea
And motion
made the offer based upon the state
motion
jail.
to revoke probation was then filed about a year later after she was placed on probation.
Yes, sir.
On it. And it states that she was placed on probation for
Yes, sir.
a state jail felony, which is obviously a mistake. And the thing is accuracy is the most important thing. And I'm looking through the file, the plea agreements, all the indictment shows it's a third degree felony. The plea agreements all reflect when she was placed on probation in 23, but everybody understood it to be a third degree felony. And
Yes, sir.
the plea agreement documents.
And the person filling in for the plea and sentencing on the MTRP just went on the basis of the fact that I had filed it as a state jail felony on the MTRP. So it was my mistake. We just all missed it. I missed it. So.
Okay, so how are we fixing this now?
We're going to do a plea to 10 years, but we've got to, if you want him to file a motion for a new trial, we got to do that first. So
2 years.
2 years, I'm sorry, 2 years in prison, which is the minimum.
Make a motion.
I'll make a motion for a new trial and I ask the court to set aside the prior judgment and enter the new judgment we just signed today.
For what purpose? To support the record. I know what it is.
Because the prior judgment would have been an illegal sentence. And we would like to fix that.
Let's look at it. Let's take it chronologically. The defendant was indicted in this case originally on February of 2023 for the third degree felony of illegal possession of a controlled substance. Subsequent to that, she was placed on
10 years
probation,
straight probation.
on yeah, she was sentenced to 10 years imprisonment and probated for 10 years. Regular probation, convicted and placed on regular probation. On July 17th for the third degree felony of illegal possession of a controlled substance that she was indicted, which is reflected in an indictment filed on February 22nd, 2023. All of that is fine and dandy until we come to disposition. A motion to revoke, it was wrong from the get-go. It's filed as a motion to revoke unadjudicated probation, and it was regular probation, not unagreed. This was filed on a year later on July 30th of 2024. And it states that she was on deferred or unadjudicated probation for the state jail felony of illegal possession of controlled substance, and that's incorrect. She pleaded true to an allegation of committing the offense of illegal possession of a controlled substance on or about November 16th, 2023, which was similar to what she was placed on probation for in the first place. The same type of drug, and then her probation was revoked. She was found guilty and then sentenced to 1 year in the state jail on March 19th of 2025, 4 months ago. Now it's been discovered that the proceeding of revoking her probation and then sentencing her was based on mistakes with the parties preparing the papers as though it were a state jail felony that she was placed on probation when it was actually a third-degree felony.
State has no objections to the new trial. And
should there be
and we'll amend that after we get the new trial done. We'll ask you we can amend the motion to revoke probation.
Yeah. Yeah. Well, go ahead. You want to do it?
Yeah. Yeah, to do it wrong.
Yes, sir. We'd move to amend the motion to reflect that it's not an unadjudicated probation, but probation, and that it would be for a third-degree felony possession. So we'd ask to change state jail to third-degree felony. Just change the word unadjudicated to adjudicated. And from 5 years to 10 years. Just take out the and it would be. Okay. And make sure you get all the language correct on it.
Yeah, I had it said. Yes.
Yeah.
All right. Raise your right hand. Do you solemnly swear or affirm the statements that you make during this hearing, ma'am, will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. And we are calling cause number 23-41608, the state of Texas versus Crystal Lorraine Anderson. That is you. And you are here with your attorney and the state's attorney. Mr. Adams, does the defendant waive a formal reading of this corrected motion to revoke probation, what we're going to call it? And can we proceed in sum?
Yes, sir.
And again, for the record, the defendant was originally placed on regular probation, sentenced to 10 years in prison, probated for 10 years on July 17th, 2023, for the third degree felony of illegal possession of a controlled substance, namely methamphetamine. Thereafter, a motion to revoke, an incorrectly made motion to revoke unadjudicated probation was filed, which alleged on July 30th, 2024, about a year later, that the defendant was allegedly on state jail probation and had been sentenced to this
1 year state jail. That was the incorrect
and
sentence.
placed her on deferred or unadjudicated probation. I'm sorry.
No, 10 years, probated for 10 years, but when she pled true to that.
No, I'm talking about the motion, the incorrect motion to revoke probation
was for
alleged that that was filed a year ago. Incorrectly alleged that the defendant had allegedly been placed on deferred or unadjudicated probation for a state jail felony.
Right.
And we carried through a judgment which revoked her probation and sentenced her to 1 year in the state jail. All of that was incorrect because she was actually on regular probation for a third degree felony. So the parties have caught that mistake. We're trying to fix it and correct it. So we now have in the file what is called a corrected motion to revoke probation. And it, in summary, and we can proceed in summary.
Yes, sir.
It states, Ms. Anderson, that on July 17th, 2023, in this court, you were sentenced to 10 years in prison, probated for 10 years for the third-degree felony of illegal possession of a controlled substance. Is that correct?
Yes.
As opposed to what we did last year, stating that in the motion incorrectly that you were placed on a state jail felony, deferred or unadjudicated probation. We all know that's not right. It just slipped by everybody for some reason. Allegation 1 states that you that you committed the offense of illegal possession of a controlled substance, namely methamphetamine, cocaine, and oxycodone on or about November 16th, 2023 in Jefferson County, Texas, which was in violation of condition 1 of your deferred or unadjudicated order. And that is obviously going to, we're going to have to correct that in violation of your probation order. We take out deferred. Is that correct now that you violated your regular probation by committing the offense of illegal possession of methamphetamine, cocaine, and oxycodone on or about November 16th, 2023 in Jefferson County, Texas? Is that true?
Yes, sir.
You just said no.
No.
You said no.
Yes, sir.
No, you shook your head no, and then you said no.
He said a verbal yes. I was just waiting for him to give me a.
Prompt you?
Yes.
Oh, okay. All right. Let's do this again, because it's got to be clear on the record that you're not making a mistake, and we don't want to make another mistake. We got to fix this mess. Is it true you violated your probation?
Sure.
Okay, by using drugs, methamphetamine, cocaine, and oxycodone on or about November 16th of 2023 while you were on probation?
Is this all happening new? Because I took that deal based on getting 3 consecutive 1 year. Otherwise, I was going to fight the 2 other charges.
No, you can fight this.
No.
We're what has happened is we're correcting, hold on. We're correcting this mistake. We're putting you back in the position you were in when you pleaded true back on 3/19, a few months ago. We are putting you back on that day, 3/19, and we're putting you back on the point in time where we were going to address this motion, and we went and addressed it incorrectly. That moment in time is where we're starting from. But as we're starting this motion to revoke probation, we have therefore corrected this motion, which never happens, but that's where we're making a big deal. Nothing can be done that we can catch that's incorrect. When we find it, we have to fix it. It has to be accurate and honest and truthful. You pleaded true to the incorrect 1 year state jail felony, which you can't get. That's not eligible for you when you were placed on probation the first time for 10 years. It's prison, not state jail felony, which is a different thing altogether. It was incorrectly on the motion to revoke probation. We all took off in a wrong direction. It's wrong. So when you find it out, you fix it, because it has to be corrected. You can't change things after they started in a direction. That's, if it's in the correct direction, you can't change that. So we're putting us back in time where this motion was filed. We fixed the motion now. It's a 3rd degree felony that you were placed on probation for. You were looking at revocation of probation, and this has been stated that you're going to be pleading true. This is what it states here. Sentenced to the minimum, which is 2 years confinement, you will be given credit for all the time that you have served, which should satisfy this. But I'm not the parole board. That's parole to decide. And then you will be released from custody when the parole people say all the I's are dotted. But your probation is about to be revoked according to this agreement. You will be, but you were found guilty earlier. We're not changing. You were found guilty of the felony. We can't turn it into a unagreed. We can't turn it into a deferred state jail felony after a year's passed. I know you follow along because this is stuff for lawyering and all that. But do you understand? I mean, you're agreeing that you pleaded guilty at the beginning, you made the deal for 10 over 10 years imprisonment, probated for 10 for a third degree felony. That's that's the road we have to continue. We torqued off on a side road when was this? On a little while ago, a few months ago. That was wrong. We're fixing it now. Do you understand? So, is this true that you're sentenced to 10 years in prison, probated for 10 years for the third degree felony of illegal possession of a controlled substance? And this alleges that on or about November 16th, 2023 in Jefferson County, Texas, you violated condition 1 of your probation order, which is don't commit a crime, by illegally possessing methamphetamine, cocaine, and oxycodone. Is that true and correct?
Yes, sir.
Are you pleading true and correct to that voluntarily and because it is true?
Yes.
Everything's fixable. We just have to take it one step at a time and do it. An agreement has been reached where you would be pleading true, your probation would be revoked, and by your voluntary and knowingly made plea of true to allegation 1 of this motion to revoke probation that has been corrected, your probation would be revoked. You would be sentenced to 2 years imprisonment and given credit for all the time that applies to that in your service in confinement.
Sure.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
I show you. Here, what's marked as State's Exhibit 1. Did you sign that document?
Yes.
Understand it? Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. This states that you are giving up all rights of appeal if I follow this agreement, which I'm going to do. Do you understand?
Yes, sir.
Anything further? Okay, I'm going to follow this agreement and find you have pleaded true today voluntarily, knowingly, intelligently to allegation 1 of this corrected motion to revoke probation, which was corrected on this day, July 21st, 2025, correcting it from a motion to revoke probation to from a motion to revoke unadjudicated probation that it incorrectly is titled, and that the body reflects it is of the motion reflected it was a deferred or unadjudicated probation for a state jail felony, which was all wrong. It was an actual regular probation for a third degree felony where you had been sentenced to 10 years in prison, probated for 10 years. We've corrected that today. You have pleaded true to allegation 1, which states you committed the offense of illegal possession of a controlled substance while on probation for that third degree felony. You have made your plea of true voluntarily, knowingly, intelligently. That is enough to grant this motion, corrected motion to revoke probation by a preponderance of the evidence or greater. I so find it is granted. The motion to revoke probation is granted. Your probation is hereby revoked that you were placed on probation for originally for the 3rd-degree felony, 10 years imprisonment, probated for 10 years. And I hereby sentence you to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. That's the very minimum. And that will resolve this. You will be given credit for all time you have served. All right. Do you understand this weird road? We fell off the path and we're getting back on the correct path, but it's accurate, I believe now. Correct, everybody?
Yes, sir.
Do you understand what has happened today?
Yes, sir.
Okay, we fixed this. Your probation is revoked. You understood it was going to be revoked earlier. You pleaded true. And it was
Double the time, it's kind of hard to swallow.
well, it's your choice though. It's hard to swallow, but you did know you did know you were on regular probation for 10 years.
I mean, that's.
It's not what I said when I sentenced you originally. No, I put you on regular probation, which is where all this stays. I mean, and there it is on the file. I mean, there's documents that you've signed. You were found guilty, sentenced, and suspended. Not placed on deferred. That torqued off last year when this incorrect motion to revoke probation was filed, and you missed. And look, there's 5,000 cases at any given time that we have in this court. 5,000, and I'm surprised more often because there's so much volume that mistakes aren't made more frequently, but they're not. It's rare. And when it is rare and we find it, we fix it. The most important thing is we want it to inure to everybody's behalf, the people and you. But when there's a mistake that's obvious, it's got to be accurately fixed. And I think this accurately fixes it. And as a consequence, I must say that for being on probation for a 3rd-degree felony of illegal possession of controlled substance and
It's a whole big screw.
and 4 months later being caught with controlled substances, the minimum sentence of 2 years is a gift.
I appreciate it.
But I know you'd rather not have to go through all of this. Anyway.
Thank you.
Hopefully, you have acquired enough. I don't know why you have it. Certainly you have. It's just going to be some days where the paperwork gets resolved and everybody signs off on it, and you should be released very shortly. Okay. All right. Good luck, man.
Thank you.
Bryce, you got something?
Hey, all right.
Okay. Pity night, please. Thank you. You'll pay me out of my misery.
Good luck. Probably.
Well, I hate seeing mistakes like that made.
Whatever.
It's a motion was wrong and nobody got it. And we went down that road on a motion, and unfortunately, a few months later, it was caught. But you gotta fix it. And actually, in the great scheme of things, she benefited from the deal. She got the minimum sentence of which would not have been normal for committing an offense a few months later, the same offense that you were placed on probation for. Serious. Okay. Okay, what are we doing today?
Your Honor, it's on the announcement docket. I believe the party filed a request for a speedy trial.
What are we doing today?
She's refusing a 12-year cap on the ag robbery. And open plea to count one of the theft.
Okay, so, and then the aggravated robbery, we just put that back on trial? The
Yeah, it's on
trial?
the truck, should be on the truck.
It's not on the trial docket. It's a newer case. This is only the second announcement on it. I'm happy to put it on the trial docket.
What I'm saying,
March 19th, it was filed.
I'd already filed a request for speedy trial. Or
Okay, it'll be put up. Okay, 25 CR 332, the aggravated robbery, that's a first degree felony
She's got
and a prior 21 conviction. So on this one, do you understand your punishment range is not what it would normally be on a first degree felony, which is serious?
explained to her.
5 to life.
So 15.
If this prior conviction is proven, if you're convicted at trial, this is proven to be true, the minimum you're looking at is 15 years in prison. And it's a deadly weapon is used here. So that means you cannot be paroled until you serve at least 1/2 of whatever sentence. So it's 15 to life. 15 to life, and you have to serve 1/2 of your sentence, and you're not very oil. It's a long time.
And the offer was a 12-year cap.
Is that right?
To count one.
Okay.
And then.
Okay. But this is always free will. Everybody has free will. You make a choice and he can advise you. But at the end of the day, it's your choice. You know what the right choice is for you in your heart. And you have to live with it, just like we all do. But is that 12-year cap taken away?
Yes, Your Honor.
Okay. You didn't want to think of that a little more?
Up to you if you want to take it.
Look, if you're not guilty of that, you don't ever plead guilty.
Right.
Fight. But I mean, some people plead guilty and it's allowed. You can plead guilty, but then we're creating fiction because you have to swear I'm guilty of this. But some people do just because, and I wish that wouldn't happen, but it's their choice and they're saying, they're swearing they are. But we know sometimes people do it because it's more convenient. And that's not the way it should be. We're all held accountable to our mistakes, and you try to resolve it in the best interest of all concerned, most importantly you. But this offer, I mean, you're looking at 12 to life and it's 50% time. It ought to be 15%. It's 50% that you will have to serve with it being aggravated, a deadly weapon being used. And if it's 15, even if you were sentenced to minimum, you wouldn't be parolable until 7.5 years if you got the minimum, which seldom is done. But that's just, you need to know, and the decisions that people make here need to be made with as much information as possible. And this is what I'm giving. And at the end of the day, it's your choice. So we're going to work on this theft case, right? 24 CR 1401. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in something?
She's not pleading.
Oh, I thought that we were pleading to something.
Nope, we're not pleading to
Oh.
anything.
Oh, what are we doing?
Just announcing, looking on the fact that she's refusing. It was an offer on the theft case to plead open to count one with restitution.
Oh, okay, okay.
If you don't want to do that.
Okay, yeah, sorry, I'm wrong on this. So we're setting these for trial. The trial, the first one, we're going to try this. It's a trial.
Is the robbery, Your Honor?
The aggravated robbery. Y'all get ready. Let's move on this.
That's why I filed a request for speedy.
Okay, let's get this trial. Let me look at something real quick. Okay.
She's actually a party, I think, in that office.
She is, yes.
She's not the president. Sure. What's that? I even tender everything else. So it's my sense.
No.
This way.
We'll make the front page. Oh, it will. All right, that's it. No deals. Okay, we're going to trial. Thanks on that.
On the trial, Your Honor, with Mr. Whiten, and she, I really want them to come back. He was on the trial docket from 9 o'clock.
Yeah, I sent something over to,
The jail case.
there was, to the, drug impact board. They had a availability.
Yeah, I'm on their trial docket also. 11.
Yeah, so I don't think we're gonna change anything yet. I got a bunch of stuff.
So you can see release then?
Hold on, let me see what this, give me a little more time. Hey, Langston, Crystal Anderson and Andrew Diaz. That was Crystal.
Yeah.
Where's Andrew Diaz?
Diaz, I have
A buddy. You have a good friend there at that table, right? And
They've asked me to consider a probation in that case, and I need a little more time.
how much time?
30 days.
You got it, 4 weeks, okay, 4? All right,
Thank you,
that's
sir.
reset 4 weeks to request the parties. Then it looks like I've got a gaggle of stuff with David Grove. Where's David? David probably left town.
Does people bring out just the rest people that want to file, get that on the record?
No, I don't think so. But that's, John's word's always been good for me.
Okay, well, you mentioned it.
No, nothing's ever changes. I mean, they don't change their mind.
I've not confirmed all of them.
Yeah, that's good enough for me. This Travante Fontenot, what is this on? What about? Sonny Eckert, what's the Travante Fontenot thing about?
He said he wanted to hire.
Yeah,
He's on the screen.
All right, Fontenot.
Either he needs to have an attorney appointed or he's come up with the money, but either way.
Okay, we hadn't brought him out yet, right? Travante Fontenot, please, thank you.
You allowed Burbank from withdrawal.
You're on the trial docket. You need me back at 1:30, just be on standby. Have a one-on-one.
But I don't think anything's.
Okay, if y'all need me, call me. But I'm
We
gonna,
only have one,
yeah, I got one at the very bottom, and if y'all need me, call me, but otherwise I will.
but is that one we could send? Is that,
It's with Mr. Eckhart. That's the problem.
what do you mean, that's a problem with Eckert?
Well, he's gonna be back in trial tomorrow here.
Well, that's not a problem.
Yeah, he can try 2 cases. Exactly.
Yeah. Come on up, sir. And what is your name, sir?
Save me on it.
But what did I do with that? With these two? These last two?
Sorry, but you give it to me. Here you go.
Thanks.
Yes.
You're Mr. Fontenot? Yes. There you go. 2 cases. You got 2 cases here. Numerical sequence, we got the 24 CR 281, which states that on or about January 25th, 2024 in Jefferson County, Texas, you committed the third degree felony of having a prohibited weapon, which carries with it, as you know, up to 10 years in prison. So then in the other 24 CR 1605, you were indicted for a newer case about 6 months later, which alleges that on or about June 16th, 2024, after you had been indicted for the prohibited weapon, that states that you committed the second degree felony of aggravated assault with a deadly weapon by shooting someone with a firearm. That's a second degree felony, which carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Then we had a motion to withdraw. Mr. Burbank was your attorney. He filed a motion to withdraw that I granted back in June. Did you ever, last month, are you hiring another person at all?
Yes, sir.
Who?
There's somebody from Houston.
Who is that?
My mom been talking to him
Well, when is that going to happen?
before I go to court September 15th.
Well, I mean, they have to have time to prepare, right? But they're not going to have much time. July, August, 2 months.
So,
Okay, well, if they're not here, you got to go by yourself and represent yourself, which is a foolish thing to do.
yes, sir.
You're not competent on the rules of evidence and the code of criminal procedure and the penal code, books that all have application for a trial for you to be effective. And you're looking, if all of this is true, this is up to 30 years in prison. And the aggravated assault, you have to, if you're convicted of that, you have to serve it. You can't be released from parole unless or until you serve at least 50% of your time. So these are serious. You got to be taken seriously. Do you know the person who's?
No, sir.
Somebody else is getting the person for you, huh?
Yes, sir.
Well, all right. Well, all right, we're going to set this on the trial docket. How much time did you say? Huh?
It's already set for September 15th.
September 15th. Get ready. You got to get ready, but your lawyer has to be prepared, and that's not giving them a lot of time on something serious like these 2 cases.
Yes, sir.
All right, just that you know. Okay, thank you. Yes.
I'm just making sure I was free to go. I know who wrote Docket. Sonny explained that he's still in trial.
Yeah, yes.
So I imagine.
Yeah, well, I sent a case over to the drug court is all I could
Okay.
do, because we're going to get back into this tomorrow, but we try to move some cases if we can.
Okay.
And I just don't think anything's going to be
I understand, Judge.
work out except to finish that other case that it's a real serious case that we're working on. And then I've got David Grove, wherever David went. He's working back there. We got to see what he's going to do. Otherwise, anything else to bring up? No? Okay, except for David's cases, which are 3 pages.
I changed. Yeah, making it. Yeah, well, it's a mission. I'll be here.
Okay, we got, that's 15 cases. So we'll see. We're on a standby here, a short recess, and see where David Grove is working. I know he's working on some stuff. Stand by. Thank you. It says 1 week.
Last
Yeah.
one is. Yeah.
Okay. Clause number 23-41527 is called the State of Texas versus Terrell Johnson. That's you, Mr. Johnson?
Yes, sir.
And Mr. Grove is here, your attorney. What are we doing today? This was set the plea, and then that's what we were told. I reset it a week for y'all to resolve whatever doubts were. Where are we?
Your Honor, I'll sign for 10 years deferred right now.
Is that what the offer is?
No, sir.
Who's the lawyer on that for the state, please? Who's got this? Who? Who's the lawyer on this?
It's the Docket Johnson.
Who's this, Jeff?
Terrell Johnson. Who's making his own deals now?
Oh, yeah.
Which you don't do.
Oh, my apologies.
Terrell Johnson is Sunny.
Fairly small.
He's saying-
Mr. Johnson says he'll take 10 years deferred.
Yes, sir.
No.
Okay.
Okay.
That's what
What was the offer? So he knows.
the offer was 8, I believe, 8 TDC. It's done today. And not for 10 years or 20 years deferred.
Is he eligible for probation? Everybody, anybody?
I don't believe he
Anybody
is.
at all?
He is not.
I don't believe
He has a
he's
prior
eligible for
conviction?
probation listed.
I don't see any prior convictions on the indictment.
You tend to have it, Judge.
We're gonna file a notice of something.
Well, no, I just want to make sure if he is, want you to.
Say first.
Pretty good at the talk. The offer was not 8, it's just straight probation. So I don't know where he came up with 8 from,
Straight probation.
but I'm not doing.
You take straight probation.
Straight probation.
Okay, what,
That can be up to 10.
5 years, probated for 10 years, $500 fine.
you would be sentenced to 5 years, not, so the worst you can lose if you're revoked is 5 years.
Okay.
At 5 years, suspended, of 10 years, and then of course you do well and you get off in the third.
So,
But that's what you want to do, sign it up,
what does it, I'm good, staying and put on probation. I don't understand.
sir.
I'll be put on. probation.
Yes, sir. Yes, sir. You would be sentenced to 5 years probation, 5 years in prison. That confinement would be probate. You're placed on regular probation for up to 10 years.
Okay.
There will be terms and conditions of probation, which are normal and customary for this type of law.
Yes, sir. I'll take it.
Okay. All right, I'm gonna put to be lead. All right, Kyle, just have a seat right over there and he's gonna work on that. Thank you. Get Mr. Johnson's first since he was first in line. Kyle Mulholland, please. I don't know why I'm doing this. This is. I don't do it for everybody else. I don't understand that they can't, that there's confusion all the time here.
Mr. Mulholland, is he the next one?
Yes.
I don't believe that he wants to take the offer.
Okay.
It was 20 years, run concurrently with a case in Llano County.
What's going on in Atlanta?
He's been convicted.
He got 20 years in Lando of sexually assaulting the same child.
Okay, in 24 CR 1375, you are Kyle Clayton Mulholland, correct, sir?
Yeah. Yes.
And the offer that was made to you.
Hold on. Let me
I'm
make
sorry,
sure that
I'm sorry,
he
Judge.
understands fully what the ramifications on this. The indictment states, that this is a that you committed aggravated sexual assault of a child, and it's a super first degree felony, correct?
Yes, sir.
Because the child is younger than 14. Also has something to do with parole too.
Yes, he's not eligible for parole on this offense because it's continuous sexual abuse of a child.
And okay, paragraph 1, unusual, states that on or about December 31st, 2018, and during a period that was 30 days or more in duration, commits 2 more acts of sexual abuse against a child younger than 14. Now we have paragraph 2 states an act on January 1st of 2018.
Yes, they're just listed the act, Your Honor.
And then paragraph 3 is on or about December 31st, 2019. Almost 2 years later.
Yes.
So the minimum is 15 years?
I believe so.
Is that right?
Yes.
That doesn't sound right. Let me verify this. But
Not the real law, is that somebody was encouraging everyone.
now, an offense under this section is a felony of the first degree, punishable by imprisonment for life or for any term of not more than 99 years or less than 25 years. So it's the super max. So it's time. So you're looking at a minimum of 25 years, and that service is day for day. There is no, that would be like the equivalent of a 100-year prison sentence on a non-aggravated case. Do you understand what you're charged with?
Yes.
Yes, sir. Okay. Then on
He only has one case, Your Honor. He only has one case.
was that it?
Yeah.
I thought-
Yes, sir. I think the offer.
It said he was already convicted in Llano of a similar.
Okay.
And the offer that was conveyed, which may not be on the table anymore, I understand that, was 20 years to run concurrent with the offer from Llano, Texas. The 20 years from that, I
Was
believe was the
the
offer.
Llano case a continuous sexual?
No, it was an aggravated sexual assault of a child, which is what we would plead him to here.
Oh, he would be pleading to a lesser serious offense here as well, and it would.
They would run.
Do you understand all of that?
Everything would run concurrent rather than the 25 to look.
Yeah, there you go, which would be stacked by law.
You understand?
Yeah,
Okay, you've thought about that and how long enough?
I need a little time to think about it.
How much time, sir?
Can you bring me back next month? I just gotta look up
Yeah.
a few things.
Yeah, I'll bring you, it'll be 3 weeks.
3 weeks? All
Okay,
right.
that puts you in I think that puts us in the next month, but
Are you gonna run it concurrent with the time frame of Llanos?
that's what y'all agreed to.
22, year of 2022?
I
That's
mean,
where
it
it
was
started.
currently from. when
No, the sentences run concurrently. They don't precede. They don't start on a precede. They'll run concurrently, but it begins from the time you
That's what I was
were
trying to ask
convicted.
him earlier.
Yeah, that's why we always you know, people have a fair amount of time to think about it, but in a case like this, if that's what you're considering, thinking about it, and if you decide to do it, you've lost that credit while you think about it, but that's because of the presumption of innocence. That's the way that's out of the Constitution.
Yeah.
So that precedes backdating a time of sentence. But the quicker people get on a sentence, if it's going to run concurrent, quicker it runs concurrent and ends, but it's their choice. You got to be careful about pushing people into that. Serious cases like this. It's got to be your choice. You just need to be aware of what the pros and cons are for you. And then you make the decision.
Yes, sir.
But if you're going to make a decision for this, you're burning credit every day. But it takes, you get a fair amount of time. And this is important. It's very serious. So nobody's going to push you.
Yes, sir.
3 weeks?
Yes, sir.
Okay, we'll see you back then.
All right.
Taylor Sedlacek. You need to sign that man up, David, when you get Mr. Johnson. We can get him on his way.
There's something wrong. Yeah, well, I will have it the job. The first foot.
Taylor, Sedlacek.
Yes, sir.
I wanted to talk to you just to make sure that what is it, 7 cases?
Yes, sir. 7 cases.
One. Yeah.
And I think they're all second, 3rd-degree felonies.
Obstruction of retaliation, a 3rd-degree felony in 1779. I'm doing it in numerical sequence. Looks like that happened on February 28th of 23. Then harassment of a public servant, another 3rd-degree felony on that day. Then in 23-161, that day, harassment of a public servant. I see where we're headed here. On that day, assault of a public servant. That wasn't a good day. On that day, another this is a 2nd-degree felony. So I'm sorry, we had third, a third, which are harassment. Then assault's first going to be a 2nd. Yeah, assault is a 2nd. A 5th case of assault, a 2nd. A 6th case, burglary, a 2nd degree. That was, this is all the same day, didn't it? All of this was carved out in the same. Indecency with a child, sexual contact, that's a 2nd-degree felony.
Yes, sir. I believe that's the way I read the indictments.
So we've got up to 10 years on 179, up to 10 years, 20 now, then 180, another 10 years, that's 30 and 181. 2nd degree, that's 50 and 182. 2nd degree, that's 70 and 183. A 2nd degree, that's 90 years and 184. And then another 2nd degree felony of indecency with a child, 101 years in prison. Okay. Where are we headed on this?
Judge, a week ago, this case was set and they asked for 1 week so that Mr. Crow could talk to his client. If that's happened, then I think we're ready to go forward today. I don't know.
Tell me. Where's
I believe that's correct, Judge. The offer was on the last case, the indecency with a child case, 8 years on that case and dismiss the other 6 cases was the offer.
Is that right? Sir,
Sounds right.
what did you decide to do, sir?
I guess I'll second.
Are you doing that on your own free will and upon discussions with your attorney?
Yeah.
Okay, y'all write it up.
We'll get it done today, Judge.
Okay. You go to the next, what's next after that? We'll get this done this morning. Derek Shepherd, please.
Judge, for some reason, I don't have that file. Or I could not find that file. I'm sure I can find that file. I just do not.
It's a motion to revoke probation.
Oh, okay. Well, that may be one.
Ten over 10. You're Derek Shepherd? Sir?
Yes, sir.
Okay, there's a motion to revoke probation, right? And, I've got a question mark about there being an amended motion to revoke probation. Who's on that, please? Mr. Boyd?
You got it? Boyd on vacation.
You know anything about it?
I will in just a moment.
There's a motion filed on May 25. Then there's a written amended motion question mark. Is that going to be done? Is there an amended motion coming down the file?
Not that I'm aware of, Judge.
Okay, this was filed on May. Interesting. Well, well, okay, so he had a motion to revoke probation last year, and we held that in abeyance. He went to ISF, Intermediate Sanctions Facility. Then we've got a new motion to revoke probation, committing the offense of unlawful possession of a firearm by a felon on April 8th of 25. Then failing to avoid persons or places of disreputable or harmful character, being committed as directed in a vehicle with somebody, a convicted felon, DeAndre Howard. Then was at a location other than his residence at 1210, which busts the curfew, and failed to pay court assessed fees. Obviously, the April 8th new crime of unlawful possession of a firearm is not a good thing. Has that been filed?
I don't know that answer, Judge, but I'll finish that. I am looking at the PC for that offense, and you are right that it all centers around that offense statement at April 8th. I can tell you with the information I have here that we can proceed with it, Judge. I do know that it's been received by our office, but that was on July 1st, but it's not been indicted.
What's the allegation?
Unlawful possession of firearm by a felon. As he was
okay.
arrested on that April 8th date.
Okay, for the allegation 1.
Yes, sir.
Well, we can handle it here. In this court.
Yes, sir.
Then it only takes a preponderance of the evidence. That's all it takes.
Yes, sir.
Not beyond a reasonable doubt. What are you going to do? Oh, David, have you talked to?
I haven't talked to you about this one, Judge.
Well, that's kind of important. It's his life. It's a big direction.
Your Honor, I will inform the court that from these notes here, I do indicate he's set to go to the grand jury on August 6th.
That's for the
new felony, yes, sir. The unlawful possession of firearm.
Well, it'd be a felon in possession.
Correct.
So it's a third degree felony,
Yes, sir.
a new. This is
That's what my information shows, Your Honor.
you know that motion to revoke probation, please.
Sir?
The motion to revoke probation.
Yes, sir.
This is the one that's filed on May 23rd, huh?
Yes, sir.
Okay, second paragraph, third line.
Exactly.
We placed him on probation for a state jail felony of theft. No, we did not. That was a third degree felony.
I think that wording is there probably because. Let me check my paper before I keep talking to you.
Yeah, it's not what you think.
So I show that the offense and the conditions are correct. Checking the
indictment. He was indicted for a third degree felony.
That is what our judgment indicates, Judge.
And what happened? Yeah, it was and
sir,
he pleaded true to paragraph 2. So it was during a declaration of a state of disaster. That's why it was third degree.
Yes, sir. So I would move to correct that, amend that language in the motion to revoke community supervision to read third degree felony instead of state jail.
Any objection?
No objection.
That's corrected.
Thank you. Thank you for catching that and allowing the amendment, Judge.
All right, David, what are we going to do on this one? What's the deal on it?
I have not.
The motion to revoke. I mean,
About it.
this is 2 months later, and it's time to move this case one way or the other. I'll do it if y'all don't. Y'all talked about anything?
No, sir.
So he could find out.
Well, what is the offer, just so that Mr. Shepherd can understand what the offer is right now, since it is being amended here as we're speaking.
I don't know a offer from
Mr. Boyd.
Mr. Boyd. I'm sorry. I needed to complete my thought there. I apologize, Judge. If I can have a moment, I'll convey.
Why don't you do that? Tell me where we're headed on that one. Okay,
Yes, sir.
Thank you. So he'll know
Yes,
what
sir.
direction. We have to have a hearing. We're going to do it soon. And I'll make the choice. There won't be a deal. We'll just move. What's his last name?
Shepherd.
Who's Shepherd? Elizabeth Stout, David.
And I have not spoken with Ms. Stout.
Brittany Sylvester. That's an MTRP hearing. William Weston. 2 cases.
William Weston's a competency judge.
You're going to
So I don't believe
you have to file a motion, don't you?
Yes, sir.
Do that. Okay. Asia Young.
Asia Young is a witness in
Until after.
a case in
Okay.
one of Mr. Boyd's cases.
When do we want to review it?
I believe since Mr. Boyd is the prosecutor and he has knowledge, we need to have him here. I've already spoken with her today. But
Well, I need
believe
another event.
Another week.
Review in 4 weeks?
That's fine.
Okay, then let's go. So I have Elizabeth Stout and Brittany Sylvester. Can you let me know something on those?
Yes, sir.
Thank you. Let's move along. We got to get going. Yeah. Yes.
I just like on Google listing, we were supposed to have this motion back in June. We were given 48 hours to have the motion back on June 16th. And we still don't have it. So I don't know if you just want to.
David, did you hear that?
I didn't get it filed in time. Yes, sir. I think that's what she said.
Can you do it tomorrow?
Yes, sir. I thought I could do it this week, but I have not been able to
Let's
get
get it
out
done,
by then.
please.
Yes, sir.
Well, it'll drop through the.
And and Weston has 2 cases.
Yes, get motion, get that filed, please, tomorrow.
Yes.
You talk to Elizabeth and Brittany and let's get these other guys disposed of if possible. If y'all can work something out, please. It's 11:30. Thank you.
Yes, sir.
Anything else? Other attorneys? Hello? At all? Anybody? Anything? Stand by. Stand by. Thank you.
There you go.
We're in short recess. Thank you.
We need further.
Taylor, Saleche,
Oh,
So
what's
check.
that? Hold up. So I will,
huh? That's what you have in front of you
sorry.
first.
Okay.
He's the one that's got the most files.
Okay, how many of these are we gonna plead to? Just one?
Most, the highest.
Which
number.
one? Which one is that? The,
185.
Saleche. Taylor?
Yeah.
Taylor, thank you.
Ready? That was. Over here, sir.
See this lady at the end.
Raise your right hand, you swear or affirm to tell the truth, the whole truth, and nothing but the true self you got.
Yes, ma'am.
Okay, think of your little right thumbprint. Place it flat there. You get up one more time. Okay, place it flat right there. Okay, go stand in front of the judge.
Hello, sir. We call a bunch of cases here, 23 CR 185 through inclusively, I'm sorry. Let me start over. 23 CR 179 through 23 CR 185. So that's, what's that, 7 cases? Taylor, Lloyd, Saleche, that's you?
Yeah.
With Mr. Grove, your attorney and the state's attorney. I think the plan is you're going to be pleading to 23 CR 185, all the other cases. And there's 6 others will be dismissed. That's 189 through 184, 23 prefix. So at 185, does the defendant waive a formal reading of the indictment and the arraignment? Mr. Grove, as his attorney, can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on or about February 28th, 2023, in Jefferson County, Texas, you committed the second-degree felony of indecency with a child by sexual contact. Do you understand what you were charged with?
Yes, sir.
This is a second-degree felony which carries with it a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what you're charged with and the punishment range applicable?
Yes, sir.
An agreement's been reached where you would be pleading guilty to this and sentenced to 8 years in prison. Other cases, the 6 other cases will be dismissed. Is that your understanding of the plan?
Yes.
If I follow this agreement, you have no right of appeal of your cases. Do you understand?
Yes.
How do you plead to this, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yeah.
I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with your attorney. Are the contents all true and correct?
Yeah.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it is admitted. Among other things, this states you are mentally competent to enter your guilty plea, which freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God.
No, not really, but sure. Yeah.
What's your final answer?
Yeah.
No. It is, a State's Exhibit 1 is part of the record for all purposes. A pre-sentence report is waived here.
Yes, sir.
I'm going to make the following findings that you are pleading.
You can't say that.
You are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in your hearing to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of the second-degree felony of indecency with a child by sexual contact. I am following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. You will be given credit, of course, for all time you have served in accordance with this charge. 6 other cases, and these are cause numbers 23 CR 179 through 23 CR 184 will be dismissed as part of this agreement. One other thing we're going to just include here. Since this involves indecency with a child by sexual contact under Chapter 62 of the Texas Code of Criminal Procedure, do you understand you have what's called a reportable conviction or adjudication for this particular offense, which requires you to register as a sex offender in a regular fashion? Do you understand, sir?
Yeah.
Failure to register properly can result in a felony charge against you. Do you understand?
Yes.
Did you fill out any documents on, do we have any documents from the probation office on this case that need to be filled out for?
Joe, you fill it out.
All right, it's going to be this one right there. In fact, I'll check it for you so you don't get it wrong.
There's none of the other cases.
And this states, and you need to fill all of this out up here at the top, please. You have a reportable conviction or adjudication which requires you to comply with Chapter 62 of the Texas Code of Criminal Procedure, Sex Offender Registration Program. Failure to do so is a criminal offense that can result in a prosecution. Also, if you move to another state that has similar reporting requirements for sex offenders, you must register in that state, and failing to do so can result in you being charged with another criminal offense. Make sure you're you understand all of this, and make sure that you complete the requirements so that you don't have additional criminal charges. I'm going to fill out this top part for you, okay? And David, fill that one up, that part where there's attorney form, okay? Okay. Get that and then get that. We're gonna copy that for the file, okay?
Yes, sir.
Do you understand what has happened today, sir?
Yes, Your Honor.
Okay. And then y'all have
I've submitted the dismissals for everything.
dismissals. Okay, thank you.
I do have a couple of questions.
Go ahead.
First of all, I have been a trustee in this jailhouse for a couple of months now. Do I get good time?
I think you
credit
do.
for that? Yeah.
Yes, sir.
Do you know how much that?
No, that's not for me to decide. They do it within the jail. And all I do is sign certain things. The amount of good time is not me to calculate. It's for other authorities. If there's a problem though, you feel like you're not getting the proper credit, you need to bring that up immediately to them.
But I do have the right to it, right?
Yes, sure.
Okay. And then second,
But it's credited toward your sentence, but this is a situation that I think you have to serve one half the sentence to be credited for parole. For parole, I mean, you won't be paroled before one half your sentence is served.
So my first parole hearing will be in 4 years.
Yeah, and that's the executive branch of government, not the judicial branch. All I can do is just tell you what the law is. They're the ones that control, and it's all up to, because they're the ones who calculate the good time, not the judicial branch, the executive branch. And then if there is a problem, then you need to file a complaint or something to address it. So it's done before it works its way down the line. Okay. Anything else?
I don't think it's really relevant, but I did try to ask this public defender what would happen if I were to renounce my U.S. citizenship.
What about it?
Like, would there be any benefit to this case at all?
No, but you can certainly renounce your citizenship. Try to get it back, though. I was United States attorney for 20 years. Yeah, they were funny. The federal government's funny about that. You want to renounce it, you have to be able to prove your worth to come back, because people who renounce generally do it for a reason that the government seems to think may be a danger to the government and the people of the United States. So you ought to think about that. But you can have dual citizenship.
Okay.
Yeah, I mean, you can have citizenship more than just dual. You can have multiple citizenships, theoretically, if that's the way you want to live. But it's a free world. Over 200 countries in the United States, in the world. Pick a few. All right, but do well. All right. Good luck. Yes, sir. Next is.
Don't let him go. I need him to sign.
Stout, Elizabeth Stout, is that right?
No, sir.
No?
Hey,
Give me another file or two.
I guess these are
I thought I had them over here, but that was this morning's file.
getting sad.
Kobe Rogers?
no, that was what this morning too, I guess.
I don't know them.
Shepherd,
Sid Johnson, Judge,
Carol Johnson.
Gerald Johnson.
Okay, we'll take that one.
Oh, let's see. Fill out that form. I was never. No. Yeah, I discovered, yeah, never seen these. No.
Judge.
I have a Terrell Johnson.
Yes, sir.
Terrell Johnson.
Yes, sir.
Man, the pen is not accepting the signature. What else can go wrong?
And I need his signature. I mean, it's stuff right.
First, yeah, go.
Gerald Johnson.
Yes.
That's right. Yeah. There's one here, one there in the box, and one beside. Think again and do it on a different place. Okay, raise your right hand. You swear to tell the whole truth and nothing but the truth and help God.
Yes.
Terrell Johnson is called 23-41527. The state of Texas versus Terrell Devon Johnson. That's you, sir.
Yes, sir.
Present. Mr. Grove, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Your Honor.
In summary, the indictment states that on or about December 24, 2022 in Jefferson County, Texas, you committed the third-degree felony of assault family violence by choking. Do you understand what you're charged with?
Yes, Your Honor.
A person charged with a third-degree felony faces a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, Your Honor.
An agreement's been reached in your case. You would be pleading guilty, sentenced to 5 years in prison. That would be suspended. You would be placed on regular probation for up to 10 years. Do you understand?
Yes, Your Honor.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, Your Honor.
How do you plead to this, guilty or not guilty, sir?
Guilty, Your
Are
Honor.
you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign up to that document voluntarily?
Yes, sir.
Did you understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 is tendered into evidence and without objection,
No objection.
it is admitted. Among other things, to state you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance and cross-examination and confrontation of witnesses. And you were totally satisfied with the representation provided by your attorney. All of this is true. It states, so help you God.
Yes, Your Honor.
State's Exhibit 1 is made a part of the record for all purposes. Looking at, do we have any reports? This is a family crime of family violence. There's not a report that he has to fill out. A registration.
It's sex registration, I don't believe, Your Honor.
No, it's not a sex registration.
No, sir, it's not.
But it is a crime of family violence.
No, sir. It's coded a certain way, but that has nothing to do with anything he has to fill out.
It can affect, I guess, his parole, right?
Parole, he's going on probation.
Well, if his probation was revoked, it could affect his parole, right? Family violence.
Potentially, but not because it makes it a certain eligibility of either halftime or quarter time. It's quarter time, this offense.
I've never seen one of these where that form is filled out as part of the plea.
But there's something, on probation, I guess it's,
One of the special conditions is.
See, it's a final conviction, so he's got to report as of somewhere. There's something that gets reported, maybe not him directly, but
Judge, it's a disposition code that goes to the states,
Yeah.
DPS.
it gets.
But he doesn't fill anything out to accomplish that.
Pre-sentence report is waived.
Yes, sir.
I'm going to make the following findings that Mr. Johnson, you are pleading guilty to this third-degree felony of assault, family violence by choking voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this offense. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. That term of imprisonment is suspended and you are placed on regular probation for 10 years. Among other terms and conditions of probation, you will be required to complete the Batterers Intervention Detection Program, and there will be other terms and conditions the probation office will review. Make sure you follow these and you do well. We can get this terminated early.
Yes, sir.
If you fail, your probation could be revoked and then you could be sentenced up to 5 years in prison.
Yes, sir.
Okay, good luck.
Thank you.
Yes, sir. Fix that. Are you still married to this person?
No, no, sir. Okay. Thank you.
We get it. Move my seat.
Derek Shepherd? Mr. Shepherd? I'm not sure. Pretty sure I don't. Is this it? Derek Shepherd?
That's right here, Judge.
21-38422 is now called the State of Texas versus Derek Shepherd. That's you, sir?
Yes, sir.
Present with Mr. Grove, your attorney and the state's attorney. There is a motion to revoke probation that was filed on May 23rd of this year. Is that what we are proceeding on today? Yes.
Yes, sir.
Raise your right hand, sir, and you get a chance. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
Lower your hand. Hearing this cause number 21-38422, you pleaded guilty earlier in this case, and this was theft of a firearm, by the way, third-degree felony. You pleaded guilty back in August of 2022 to this. You were sentenced to 10 years in prison, and that was suspended. You were placed on regular probation for 10 years, ordered to pay $2,000 in restitution, among other things. Then in January, a motion to revoke, January of 2024, a motion to revoke probation was filed then. You pleaded true to allegation 1 and allegation 8 of the first amended motion to revoke probation filed in January of 2024, and you made those pleas in May of last year. And then the court found those to be true, but held the motion in abeyance, further proceedings, and then sent him to ISF, and that's not what I did. How come this is on the file? It's just what it says on the.
I apologize, Judge. You did at that time, but at some point in time, you resolved it all and sentenced him to 10 years over 10. That's why this is an original motion that you're looking at today. What you were reciting is accurate history as to how his case was handled. But it was after that that he was placed on.
When he pleaded guilty in August of 22. Then in January of last year, a motion to revoke probation was filed.
Yes, sir.
And then here's the ISF order that I signed on October 23rd, sending him to intermediate sanctions facility.
Might not reflect that was on May 28th of 2024. At that time, he did have another case that was pending. It was a state jail offense, and he was sentenced to 9 months in state jail in order to ISF on this case. And somewhere in that process, it was changed to. No, that's accurate. That he was ordered to ISF because he still had $2,000 that was owed on restitution on this fact.
You did not go to the intermediate sanctions? You did?
We did.
Yeah. Yeah, there was a motion to revoke probation filed. Subsequent to that hearing I just talked about, but I did not sign it. Okay, and you were arrested for ISF instead. It said MTRP filed by mistake, not signed. Okay, it was filed. I did not sign it. And so then in December of 23, no, stand by. January of 24, we had a first amended motion to revoke probation, pleaded true in May of 24, about 2 months ago. That was a first amended motion.
The only thing I question from what you recited, Judge, is I don't believe that motion was held in abeyance. That's why the state filed an original motion here on May 23rd.
Okay, on May 2nd, I get an administrative hearing stating committed the offense of unlawful possession of a firearm in April and failed to adhere to a curfew. And
so
what's before us today is a motion to revoke probation where he was sentenced to 10 years in prison, probated for 10 years on August 31st of 2022 for the third degree felony of theft of a firearm.
Yes, sir.
All right. Does the defendant waive formal motion reading of this? Can we proceed in summary?
Yeah, sure.
And raise your right hand, sir. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Is that true that on August 31st, 2022, in this court sentenced you to 10 years in prison, probated for 10 years for the third degree felony of theft of a firearm? Okay. Allegation 1 states you committed the offense of unlawful possession of a firearm by being a convicted felon on or about April 8th, 2025 in Jefferson County, Texas, in violation of condition 1 of your probation order. Is that true? Yes, sir.
We don't need anything else besides that, Judge.
Are you pleading true to that voluntarily and because it is true as it is alleged? Do you understand that a voluntary and knowingly made plea of true to one or more violations of probation, that is enough to grant this motion to revoke probation. Your probation can now be revoked by a preponderance of the evidence or greater. You can be sentenced to no less than 2 nor more than 10 years confinement in prison because of that. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. An agreement's been reached where you would be pleading true, your probation would be revoked, you would be sentenced to 4 years in prison, given credit for all time served. Is that your understanding of the plan?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
Show you here what's marked as States Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence.
No objection.
Without objection, admitted. This states, among other things, that if I follow this agreement, which I'm going to do, you have absolutely no right of appeal. Do you understand?
Yes, sir.
All right. I'm going to follow this agreement, if nothing further, and find that you are pleading true to allegation 1 of this motion to revoke probation filed on May 23rd of this year, where you have admitted to committing the offense of unlawful possession of a firearm by a felon on or about April 8th, 2025 in Jefferson County, Texas, in violation of condition 1 of your probation order. And I find this true by preponderance of the evidence or greater. Thus, your probation is hereby revoked. And I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years. Do you understand what has happened today, citizen? Okay. That is all. Next. One of y'all two, anybody? What is your name, sir? We already took care of you. And we took care of you as well.
Yes, sir.
Okay.
I think they're all taken care of, except Mr.
I thought there were a couple others in the box.